Okay, we will call the August 18th meeting to order. And Amy, will you please call the roll?
Here. 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 Here.
Here. Thank you. And we will stand for a salute to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. The notice requirements of the Open Public Meeting Law for this meeting have been satisfied. A copy of the notice having been sent to the Asbury Park Press and the Coaster and filed in the office of the Township Clerk on July 22nd, 2022. There is an emergency exit through the courtroom doors and 2 exits at the rear of the room. There will be no smoking. No new cases will be started after 10 o'clock p.m. and no new testimony taken after 10:30 p.m. In addition, the applicant will be limited to 45 minutes of testimony. All meetings will be video and audio taped and shown on the Township of Ocean's Community Cable Channel, Channel 22 on Verizon Fios, and Channel 77 on Cablevision. All cell telephones must be turned off, or if you need to make a call, please make your call outside the meeting room. We have the following resolutions for memorialization. Michael and Kathleen Nari, Block 33.01, Lot 1, 536 Apple Drive, Oakhurst. Bulk variance approval. Daniel Tabelli, Block 11.01, Lot 6, 208 Lockwood Place, Ocean. Bulk variance approval. Gold Coast Automotive, Block 3, Lot 7.01, 2123 Highway 35, Ocean. Bulk variance approval, use variance approval, amended site plan approval. Raymond Saka, Block 40.02, Lot 17, 502 Deal Road, Ocean. Bulk variance approval. Kyle Smith, Block 19, Lot 10, 210 Cedar Street, Ocean. Bulk variance approval. Kenneth Tawil, Block 12.07, Lot 5, 7 Oakwood Avenue, Ocean. Bulk variance approval. Joseph Shira, LLC, Block 26.04, Lot 29, 9 Abbess Place, Ocean. Bulk variance approval. Renee and Jeff Mass, Block 110, Lot 23, 1306 Stewart Avenue, Ocean. Bulk variance approval. And if someone will offer.
I'll offer.
Is there a second?
Second.
Amy, will you please call the roll?
Yes. Yes. Yes.
Yes. The following cases are carried to September 15th, 2022 to be held in person in the public meeting room, Municipal Building, Deal in Monmouth Roads, Oakhurst, Ashkenazi, Block 11.01, Lot 3, 1036 Norwood Avenue in Ocean. Sean Realty, LLC, Block 141, Lot 3, New Jersey State Highway, Route 66, Asbury Avenue in Ocean. Vincent B.N., Block 115, Lot 6, 1900 North Wanamassa, Ocean. Cordoba Ocean, LLC, Block 205, Lots 2 and 3, 1309 Herbert Avenue, 1312 Allenhurst Avenue in Ocean. Seaview Corporate Park, Block 149.01, Lot 1.01, 2603 Route 66 in Ocean. 199 Highway Road, LLC, Block 25.16, Lot 2, Highway Road, Ocean. Sorora Land Development, Block 22, Lots 85 and 85.01, 280 Norwood Avenue in Ocean. Kane Brewery, Block 176, Lots 1 and 2, 1750 Bloomsbury Avenue in Ocean. Stephen Shamey, Block 25, Lot 141, 606 Corley's Avenue in Ocean. And Township of Ocean, Block 159, Lot 1, 100 Cold Indian Springs Road in Ocean.
If I just may, any of those going to have new notice?
think it was one.
280 Norwood will have to get
Which
notice.
one?
And
280 Norwood? 280 Norwood is a
Which one?
280 Norwood. Ashkenazi.
That's 1030 and Sorora.
Sure.
Other than Ashkenazi and Sorora, all of the other notices are accepted. The board will accept jurisdiction and be carried without the necessity of any further public notice or publication or mailings, other than Ashkenazi and Sorora land development. They'll be carried.
Okay.
And before we start the first case, Madam Chairman, I would request that the board move to executive session to discuss some pending litigation.
Okay.
You would need a motion to adjourn to the executive session, which we do out of the public's eye. We'll go back upstairs, sorry.
Okay. Is there a second?
Second.
Amy?
Yes. Yes. Yes.
Yes.
Yes.
We're going up to the caucus room. I don't think this will take more than 10 minutes.
Okay. So our
Call the Larchwood.
continued case, Larchwood Mignon, Block 8.02, Lot 3 and 23, 48 Larchwood Avenue, Ocean, Zone R1. This is an application to expand the existing synagogue building and construct an additional accessory building for use as a mikveh and any other related site improvements. Many variances are required as well as some waivers, and the variances are listed below. And Ms. Krimko.
Thank you, Madam Chair. It's a pleasure to see you in person, other than in Dean's and at the board, or should I say Greens now. And like Greens, the Larchwood Mignon has changed its name, and I did submit that. So the applicant is now the Larchwood Synagogue, Inc. And that was submitted a couple of hearings prior ago. As the board may remember, we were close to finishing at the last meeting. We were on Zoom. It was getting late. Mr. Gazarovski had indicated he has one more witness, his traffic engineer, who was not available that night, and that he would be available for the hearing tonight. It's my understanding that Mr. Gazarovski intends to introduce not just his traffic engineer, but additional witnesses, as well as repeating a witness that has already testified. I want to remind the board what we discussed at the last meeting, that, as you know, the statute requires a decision within a certain time frame. We have repeatedly extended that time frame, recognizing that everyone has their due process rights to present an objection and appear before the board. We adjourned it once at the request of Mr. Gazarovski in an attempt to settle, and that didn't work out. And we adjourned it at the last meeting so his traffic engineer could be present. Our intention is to have the board finish the hearing and vote tonight. So to the extent that repeating witnesses is going to extend the time past what is normally allowable, I would request that we be permitted to have Mr. Gazarovski complete his objecting case, make his closing arguments, and allow me to make the closing arguments, notwithstanding the regular 45-minute rule. I know that the zoning board rules and regulations allow for the rules to be amended at the discretion of the chair. So I'm asking the chair to allow this to finish because we're out of statutory time.
Yes, granted.
Thank you.
May I address the board?
And one more thing. I know that Mr. Gazarovski wants his witness to sit next to him and doesn't like when I stand looming. So when his witness approaches, so she or he can conveniently sit next to him, Mr. Gazarovski, I'm just going to move my chair over so I can observe the witnesses.
Okay.
Yeah, I appreciate that. Madam Chair Lady, normally when I'm addressing the board, I could stand. Because of certain circumstances, I would appreciate the courtesy of being able to sit. I just had a procedure done here.
Of course.
Okay, thank you. Also, I note, of course, that there are 6 board members sitting this evening, and we need 5 affirmative votes for this to pass. Does Ms. Krimko have any objection to this matter being decided by the 6 individuals who are seated?
You know what,
Ms. Krimko will make that decision at the conclusion of the hearing.
yeah, just have to do that.
Now, earlier on, I spoke to Mr. Kirk, and we had established certain guidelines with regard to time how much time will I be allowed to have as far as presenting the witnesses I have this evening?
We would like for you to utilize 60 minutes at this point, which will bring us to 9 o'clock.
So what time?
To 9 o'clock p.m.
Let's see where your status is at that point, and we'll make a
Also,
decision
my,
after
well, my
that.
conversation with Mr. Kirk, respectfully, is we were going to begin about at 7:30 or 20 to 8.
You're gonna-
Obviously, we're starting later than.
All right, we'll give you the time. Let's
Okay.
get started. We'll figure it out.
Thank
I mean,
you.
if there's 5 hours to go, then we're not going to be able to. But if it's another half hour,
I'm sorry?
No, let's move.
let's move.
Fine,
We'll
let's
give you
go.
time.
Let me call my first witness, my client, Emily Hedaya.
Madam Chair, one other point of order, anticipating that I may have some objections, whether it be to relevance or the like, I would just ask that Mr. Gazarovski instruct his witnesses not to continue speaking over me during my objection, and allow board the chair to consult with the attorney and make a determination on the objection.
Okay. Noted.
Yeah, I think that was kind of unwarranted, but having said that,
Okay.
I appreciate the comment. Also, with regard to exhibits, I did in fact provide copies of exhibits to the board attorney as well as Mr. Kirk. I did not provide copies to the board, so the board does not have them, and when we mark them, Mr. Steinberg, you'll address that, correct?
Well, we'll have to hand them out and have to see them.
At that time, yeah.
I don't have them.
They were delivered to you.
They weren't delivered. They were sent in
They
an
were
email
emailed.
of 100 some odd pages, which I did not print yesterday afternoon. That's not our obligation to do that.
Why?
It's not my obligation to sit and
Okay,
print
fine.
125 pages.
All right.
And the board, you have multiple copies for the board?
What?
The board usually gives, well, proceed. Let's go, see what you got.
Ms. Hedaya, you along with Mr. Seller are residents of the Township of Ocean, are you not?
Yes, we are.
In essence,
Oh, I'm
today
sorry.
is one
They have,
witness.
yes. Ms. Hedaya, do you affirm to tell, will you raise your right hand? Do you affirm to tell the truth, the whole truth?
Yes, I do.
Okay, thank you.
Okay. Mr. Hedaya, you are a resident of the Township of Ocean, are you not?
Yes, I am.
And when did you first become a resident of the Township of Ocean?
1991.
Okay. And in 1991, were you a single person or were you married?
I was married.
And to whom were you married?
Stephen Hedaya, my husband.
Now, you, what is the address of the residence where you were residing at that time?
7 Old Farm Road.
Okay. And do you know the lot and block?
I'm not sure.
Okay.
8.34, I think it
Okay.
is.
But that was a home which you resided in with your husband, and did you have children at that time as well?
Yes, we had 2 and we had a third on the way.
Okay. Now, with regard to that residence which you just described, 7 Old Farm Road, have you resided in that residence continually as your place of residence since 1991?
Yes, we have.
Do you vote in the Township of Ocean?
Yes, I do.
Did your children go to school in the Township of Ocean?
Yes, they did.
That has been the only residence which you have had all during that period of time.
Yes.
Now, did there also come a point in time, whether it was prior to that or subsequent to that, that you also purchased an additional parcel of land in the Township of Ocean?
We purchased that parcel in 1977. My husband purchased it.
Okay. Now, with regard to the property which you purchased in 1991, in whose name is that title?
That is in my name.
Okay. With regard to the other parcel, in whose name is that?
My husband's.
Okay. Now, is there also a residence that was located on the parcel owned by your husband during that period of time?
No, it was a vacant land.
Did there come a point in time in which you transferred title to that parcel to another individual?
Yes,
You recall when that was?
2017.
Okay. Do you know whether or not that individual has constructed a residence?
They have.
Okay. Now, with regard to that, During that period of time, from 1991 forward, were there other residential homes located on Old Farm Road?
Yes, many.
Would it be fair to say that many of the residents who lived on Old Farm Road were of the Jewish faith?
Yes.
Now, are you familiar with the customs and traditions of the Jewish faith?
I would like to think so.
Okay. Now, do you know what a minyan is? M-I-N-Y-A-N.
Yes, a minyan.
A minyan. And what is that?
It's a quorum of 10 men necessary to have a prayer.
Okay. Now, can that be conducted anywhere in a residence, in a bowling alley, outside in a ballpark, or wherever it may be?
Anywhere, even in the back of an airplane.
Okay. Now, during that period of time, from 1991 to perhaps the year 2000, to your knowledge, were the minions conducted in that neighborhood on Old Farm Road?
Yes, there were.
And where would they be conducted?
They were conducted in different individuals' homes.
Okay. Now, did there come a point in time that the residents living in that area had the opportunity to purchase a parcel of land that is the subject matter of this application?
Yes, I believe that happened in 2013.
Okay. Now, do you know the purpose of why they were seeking to purchase it?
I think they needed somewhere to host the Old Farm Road Minyan.
Okay. As a matter of fact, it was known as the Larchwood Minyan, was it not?
It was known as the Old Farm Road, and then when they purchased, or I think they leased it at first, then it became the Larchwood Minyan.
Okay. Now, did you have any objection at all to the utilization conceptually of that building or that home as a minyan?
It's a home, and I did not.
Okay. Did you have concerns that it might be utilized in a manner other than simply as a minyan?
Yes, I did.
And did you inquire as to how it was going to be utilized, and did you take any steps, whatever, to ensure that there were certain restrictions which were put in place to limit the manner in which this residence would be utilized?
Yes, I did. I appeared before the board in 2013, and I retained counsel.
Okay. Now, who did you retain?
I retained Mr. Gazarovski.
Okay. Did you know whether or not the applicant, meaning the Larchwood Minyan, also retained the services of an attorney?
Yes, they retained the services of Mr. Peter Falvo.
Okay. Now, did there come a point in time when there was a public hearing held before a zoning board of adjustment?
Yes.
Okay.
Madam Chair,
Well, let's see where it's going.
I'd like to place an objection on the record. What we're doing is now reiterating the history of this application since 2013. We're not here to figure out how we got here, and it was already ruled that the property agreement between private property owners are just that, it's been litigated in court. I would ask that Mr. Gazarovski focus the questions on the current application and the objections with regard to the amendment of the conditions, not the history of the sentence.
I would disagree with that. The earlier approval of this matter back in 2013 contained some of the same conditions, so to say, that are presently before this board. It's part of the history of this case, and in
But there-
fact, what the applicant
we
is
know-
doing is seeking to amend that approval.
Yes, but the board has seen the prior resolution, has seen the agreement. It's all been presented to the board and part of their packet. We have it. We have the history.
Okay, so just so we're clear, all right? You're saying what is presently before the board, and as part of the evidence in this case, would be, for example, the notice of hearing for the application of the Larchwood Minyan back on May 14th of 2013.
No, this is a brand new hearing.
Yeah, but look, Mr. You just simply said that the board has those documents. They know
I
what
said the
that's
board
about.
has the resolution
Okay.
and the agreement between Ms. Adea, Mr. and Mrs. Adea, and
That's actually just Mr. Hideo.
Adea and the Larchwood Mignon.
Right,
Yes, they have those things.
Well, are they in evidence?
Yes, they're part of the packet.
Oh,
That
that's
was-
my question. My
That was the
question
board's
is-
packet.
My question is that there was a notice of a hearing back in 2013.
But what does that have to do with this hearing?
Well, certainly it has, what it has to do with the relief they were seeking, which was incorporated into.
But they
the
were
resolution.
granted that relief as per the resolution that the board has in their possession.
They've operated that way for nearly 10 years,
Yeah.
and we're now seeking to amend those conditions.
Can we
what was approved back in 2013 was by way of a settlement.
Not with this board. This board ruled on the application. As part of the findings of fact, there was a settlement.
And you're saying, are you taking the position that the settlement itself is not a part of the record in this case?
It is part of the record, and the settlement is part of the record, but it is I don't find it to be binding on this board. It may be binding between Mr. and Mrs. Hedaya, Mr. Hedaya and the Large Juan Mignon. This board has the right to change conditions.
Okay. Having said all of that, and to a certain degree I accept that, why would not the notice of the hearing where they outlined the relief they were seeking be a part of this record?
Because that was 10 years ago.
I'm not asking you for advice on this.
I just don't see the purpose of the notice when we have the results of the meeting by way of a resolution.
Okay. Let me just note for the record then that I object to the ruling which you have made. We'll make that a part of the record
Okay.
rather than beat it to death. Just so we're clear also with regard to time, when I spoke to my colleague this morning, he indicated that we would begin this hearing with regard to the case for my client at approximately 7:40 or so, and I could then proceed for, I believe, until about 9 o'clock, and then you said that
We'll give you more time. Just go.
Now, having said that, was there also a now, we may run into the same question arising here. Was there also, to your knowledge, a property use agreement entered into with regard to lots 3 and lot 23, block 802, between David R. Braha and Renee Braha, who were the owners of the subject property, the Larchwood Minion, who is the applicant, and Stephen Hedaya, who is a property owner? Are you
Yes.
aware of that?
Yes.
We're aware of that.
That's part of the
That's-
record, Madam Chair.
Once again, that's part of the record, and that can be considered by the board.
I don't know about being considered by the board. It was introduced and it's part of the packet.
Okay, so once again, I'll note my objection, I'll preserve my objection, and we'll proceed forward. But it is part of the record.
Definitely part of the record.
Now, ultimately, Ms. Sadeh, you're aware of the fact that there was in fact a resolution of the Zoning Board of Adjustment, which is dated September the 12th of 2013.
Yes.
And that, you're saying, is also a part of the
The
record?
board has in its packet the resolution from 2013.
I would move that also be made an exhibit in this case. I'm preserving my objection to your ruling.
It is an exhibit.
Now, are you familiar with the terms and conditions of that resolution?
Yes.
Okay. I want to draw your attention to paragraph 6 on the 3rd page of that resolution.
Wait, number, which exhibit is that? Oh, here it is, number 3. Yes.
Now, we know that the resolution speaks for itself, but I would like to just highlight a couple of points and draw your attention to paragraph 6 of that resolution. Can you see it?
Yes, I do.
Can you read it to the board, please?
Yes. The site is limited to a house of worship for the Jewish Orthodox faith and only on the Sabbath, which runs from sundown Friday through sundown Saturday, and on Jewish holidays only, with no use of the facility for the traditional daily service in the morning and evening hours during the week or on Sunday, except on Jewish holidays, no use of the facility during the week for educational classes, no use for a catering facility for parties, and no use for the property for receptions, celebrations such as weddings, bar mitzvahs, and brises. No use for a summer camp or other outdoor recreational facilities, and the applicant shall remove the tennis court, basketball court, and other amenities on the site other than the pool and pool house, both of which will be secured so as not to be usable.
How about read further, please?
Chair, I have an objection. I don't appreciate that I submitted to the board when this originally was submitted. The applicant is not being submitted as an attorney or a planner. Her interpretation or her feelings about the resolution are irrelevant. We are here to ask for amended conditions. If he has questions to his client about what her objections are to amending the conditions, obviously I'm not going to object. That's the very purpose of an open public meeting. But to take all this time to have her read the resolution in, that I've moved into evidence, that we've discussed ad nauseum now at the third meeting, I have to place an objection. To me, it feels like time is being stalled to get yet another adjournment to a subsequent meeting.
I'm not looking for an adjournment.
Mr.
No,
Gazarovski, I do
Mr.
have a
Manager
question.
You know, other than,
basically gave us his life history.
but let's, can we move it along?
Mr. Gazarovski, I do have a
The
question.
conditions exist. We know that Ms. Hidea is against amending the conditions. The application is to amend the conditions. Can we get to the point to her objections?
Having said that, so now,
Can we,
now
Madam Chair had.
I have a question. You mentioned that you have a traffic expert
yes, I do.
to testify as well as Ms. Hidea.
Yes.
And was there a third person? Or
Yes,
it was just the
a,
two?
Architect as well.
And the architect. So just for the sake of time, I would ask you, I would have to agree with Ms. Krimko's objection. We do have the information. If you can please just ask questions specifically related to the amended conditions that they're seeking, because I do want to allow time for the architect as well as the traffic
Having said that,
experts.
so, and I respect your comment, then can I also, you're saying that the resolution is a part of the record and it's in evidence. Is that also true with regard to the notice for the hearing of the property use agreement? They're in the record and they're part of the evidence as well.
This hearing tonight, not the one from 2013,
Well, the resolution is from 2013.
but the resolution is part of the record. The notice for that hearing is not part of this record.
Why wouldn't that be a part of the record if it was considered at the hearing in 2013?
Because the
In order
results,
for the board to take...
the notice may have been totally different or it may not have been granted the same relief as requested. The resolution is the ultimate determinative document after the hearings of 2013.
Wasn't the property use agreement incorporated into the resolution?
Are we, okay, I'm sorry, I apologize. We're at a timeline. The zoning board of adjustment attorney has ruled. We need to get past this one point and move forward.
Let me do this. At this particular time, let me just hold Mrs. Hidea's testimony in abeyance, and I'll proceed to call my architect and my traffic consultant.
Madam Chair, just one question for the record. I was also told that Mr. Gazarovski intended to reintroduce his planner. I would just ask that you can inform the board of that as well.
Okay,
I
please
can hear what you
proceed.
said.
You had indicated to me that
I
you would
did,
be calling
right.
Mr. Gemma, so you had just offered that you're only calling the traffic engineer and the architect. I was asking if you could please give a list of your witnesses.
I guess I misspoke. I would include Mr. Gemma in those additional.
I thought his testimony was finished at the last hearing. Did you present him?
This is a hearing. Testimony
Did you present him
is
last
never
hearing?
finished. You could always recall the witness to clarify certain issues.
Let's not, by the time we argue over it, we can hear it, okay? So that, I don't wanna waste the time.
So let me call Mr.
Let's get the traffic
But
expert.
I just have one question for Mrs. Sadea based on the testimony that you offered.
I'm going to call her back. You can ask her that.
Well,
Okay, so now.
Let me call Mr. Wright.
But he wants, let her answer
Sure.
now before it leaves your mind.
Mrs. Sadea, you had agreed with your counsel that your only home is a home at 7 Old Farm Road. You and your husband not own homes in New York as well?
No, we sold that home.
So you, okay, so what you had said from 1999 to present, your only home was in 7 Old
That was
Farm
our
Road?
main
I'm going to object to the question because she testified that was where she resided.
No, that's not what she testified.
Yes, it is.
So again, can I ask the question, was 7 Old Farm Road your only home from 2013 until present?
I'm going to object to the relevance of that. What if she owned 100 homes? What does it matter? She owned a home on Old Farm Road.
She can ask the question, because she said she only owned, that's where she lived. Does she have other homes? Well, no. I don't know the relevancy either, but let's get the question.
Did you own other homes during that time, or did you solely live at 7 Old Farm Road?
We owned another home from 2006 to 2015, I believe.
That's all.
Okay. Your
Let me
traffic,
call Mr. Wright.
apologies, I had recent surgery.
You need this?
No, that belongs to Mr. Gazarovski.
Okay, Mr. Wright, if you will raise your right hand. You can.
You can sit.
Thank you.
Do you affirm to tell the truth, the whole truth?
Yes, I do.
Okay. And have you testified before this board before?
Actually, I have.
Okay. And if you can just tell us briefly about your credentials.
All right. I am a licensed architect.
Okay.
Okay, my full name is Eugene D. Wright Jr. I am W-R-I-G-H-T. And I'm with the Letterer and Wright Partnership, 16 Madison Avenue, Toms River, New Jersey. I have a degree in architecture from Virginia Tech. I'm a licensed professional planner and licensed architect in New Jersey. I'm a member of the American Institute of Architects and a member of the New Jersey Society of Architects. I am currently the chairman of the Ocean County Construction Board of Appeals. I've held that position for almost 30 years.
Okay. The board will accept.
Any objections?
No, the question is, who's only testifying as an expert for architect,
That is
not
correct.
standing over.
That is correct.
Okay, Mr. Gazarovski.
Thank you. I'm looking for one exhibit which I have here. If you'll bear with me, please, for 1 second. Does the board have a copy of the architectural plans for this application? Were they marked in do you have them with you today?
No, I don't.
Why would you not have them with you if they were part
We
of
have
the...
them in the file.
Have them, Mr. Gazarovski.
We have them in the file.
Because it's not my job to procure your exhibits. Mr.
It's your job to...
We have.
Mr. Gazarovski,
we have
you
it
can
in
continue,
the
please.
file. We have them. We'll pass them out.
Okay. Mr. Wright, did you have occasion to speak with me with regard to this application?
Yes, I have.
Are you familiar with the site?
Yes, I am.
Are you familiar with the architectural plans that were prepared and reviewed?
Yes, I am.
Okay. What comments do you have with regard to, first of all, the existing home or existing residence which is presently utilized as a minyan or a synagogue there? What is the square footage of that?
Let me go through that. The existing square footage is 3,851 square feet.
Okay. And is there also a basement reflected in those plans?
There is a basement, and it's a little bit vague. It's been crosshatched on the plans prepared by Massa Multimedia.
And what is the approximate square footage of the basement?
I have to make an assumption that the basement, it kind of mirrors the first floor plan, because the plan itself is vague.
What would be the total square footage then of the existing facility?
Then we're looking at probably close to 7,600 square feet, two levels.
With regard to the proposed structure that is reflected as being an addition to this home, did you also familiarize yourself with the square footage of that building?
Yes, I did. That particular building is 8,723 square feet, and apparently it has a full basement below it.
Okay. Now, is there any dimension showing the height of the basement located within that facility?
There is no dimensions indicated on the plan whatsoever.
Now, with regard to the basement of the new facility, is there also provisions in there for ingress and egress into that basement from the outside area?
There appears to be, and again, there's a bit of a discrepancy, I think, on the plans. There was the stairwells appear to be all internal on the basement plan. However, on the floor plan, there seems to be a stair between the old and the new. I'm not sure where it is going.
Okay. Now, do the architectural show the nature of the construction of the basement?
There is no detail whatsoever. It's just a big open space.
Okay. As an architect, is it your opinion that that open space in the basement can be utilized for a use other than just simply open space?
Certainly, with the proper code review, with the proper egress elements, and perhaps sprinklers, could be used for almost anything.
And what is the square footage of the basement area?
That is 7,751 square feet.
Now, with regard to the upper level, What is the square footage of that?
8,723 square feet.
As I understand it, the upper level, this is really basically a one-story building, is it not?
That is correct.
Now, did you also take note of the amount of seating which is proposed within those buildings?
Well, you want to start with the basement?
Yeah.
Okay, the basement, you have to make a, you have to summarize to a certain extent. The International Building Code 2018,
I don't, he asked you how many seats are on the architectural plan, did he?
I didn't hear you what you
Or
said.
did you ask him how many seats are shown on the architectural plan?
Yeah.
Well, he's now telling you what he thinks he can put in the basement. He's not answering your question. And by the way, there's a proffer that the basements will not be used for anything other than storage.
So again, Madam Chair, point of record, and I don't remember seeing Mr. Wright on this one at any time, because I don't know if you have any testimony or architect. So we're expecting this not going to be used for storage, and that the applicant will gladly set a condition to that effect. So how it might be used contrary to any approval, I don't really understand the relevance. Additionally, the number of seats are clearly on the plans. Our architect testified to the number of seats. It's in our traffic engineer's report. Our traffic engineer testified to the number of seats. I'm not sure why Mr. Gazarovski's witness is now restating the plans. If he has any expert opinions with regard to the plans relevant to the application and the objection, I would ask that we get to that.
The question I asked, I believe, had to do with the basement and its use. So Ms. Krumko has now said that she's prepared, if in fact this matter is approved, there will be specific language that will be agreed upon by the professionals as to the restricted use of that basement. Is that correct, Mr. Steinberg?
Yes, and she had offered that prior to tonight's hearing,
No.
several times.
With regard to the upper level, there is in fact a reflection in the plans for the seating which would be permitted or laid out in the upper level, correct?
there is a, there's some square footage in there, and what I did was I took that square footage and interpreted it into tables and chairs or seats. And I could give some gross numbers on that if you like that.
No, the number of seats and whatnot and chairs is in the actual plans themselves, which are a part of this record. Now, with regard to the buildings themselves, there are two buildings, are there not?
Correct.
And now, did you visit the site?
Yes, I did.
Did you drive around the area itself?
Yes, I did.
Is it your opinion as an architect, could you state whether or not you believe that the proposed building, starting with the mikveh, is that in not compliance, but does that lend itself to the ambiance of the type of surrounding architecture in the area? First of all, is there any other mikveh located in that area?
That I'm not aware of.
Is there any other type of second building which is utilized as an accessory to the main building, such as a garage or something else of that nature?
No, I believe we're looking at really the mikveh, the addition, and the existing building.
Right. Okay. Now, in your opinion as a professional architect, does the architectural style of the proposed building fit in with the architectural ambiance of the entire surrounding area?
Well, the surrounding area is really a residential area, and I'd have to say no. First of all, the new addition, the wall height is almost 15 feet tall for a one-story building. Typically in residential construction, the wall height is 8 foot, most of the time 9 foot or 10 foot, so it's significantly higher. The building also has a very commercial look to it. It kind of resembles really a medical office or a business office, and that's kind of lends itself towards the repetitive window spacing, very similar glazing and sizes. There are commercial storefront entrances and windows, which are called out on the architectural plans. And just basically the footprint, a one-story footprint with all these parts put together is 15,344 square feet. I don't think there's any building anywhere around residential that has a one-story footprint of that size.
Okay. Now, with regard to the exterior of the building, and as you pointed out, the window treatments and the windows themselves, is there any other building on that block or in that area that has a similar architectural style?
I'd have to say no.
Now, wouldn't it be fair to say that in no way does the proposed expansion of this facility resemble a residence?
It does not, in my opinion.
Now, did you travel throughout the surrounding area looking at houses when you were doing that?
Yes, I did.
Yeah. I have no further.
I have a few questions, Madam
Are we-
Chair. Mr. Wright.
Yes.
Yeah, you
He
said
said he
you-
was finished.
Oh, because I was talking to Jim, I apologize.
That's okay.
I didn't think we'd be that fast.
It indicated that you traveled the neighborhood and that there were no other accessory one-story structures with residences? Did you not see detached garages, pool houses, tennis pavilions?
I don't believe that was the question I thought I answered.
You specifically asked you, were there any other accessory buildings to the primary use in the area, and you said no.
That wasn't the question.
I think that was the question.
We can all watch back on YouTube, that was the question. But I have another question.
I heard you asking the surrounding neighborhood, are there any other outbuildings, basically?
That were unrelated, with a separate use of it. This has a mikvah.
Well, you didn't say separate use, you
didn't
said,
say
you were
use,
talking
you said-
about other buildings, accessories.
So again, moving on.
But we know it,
Most importantly, you indicated that this building is not residential in nature. Are you familiar with the conditional use standards for the synagogue in Ocean Township?
Not a fan.
So you wouldn't be aware that there are no architectural standards as it relates to houses of worship in this zone, nor is there any requirement in the ordinance to make it residential?
Well, the question from council was,
I didn't ask you what his question was. I heard it, Mr. Wright. I'm asking you a question. I have another question.
we have no,
Are
we
you
have no standard.
familiar with the church?
which church?
Any church, generally,
Yes,
architecture of
yes,
churches generally.
Yes,
Do they typically look like homes?
do not.
Are you familiar with a mosque? Generally.
I'm going
Somewhat.
to object to the relevance of that question. What is it?
It's
We
entirely,
all know what churches look like.
again, it's entirely relevant. He's indicating that our home, that our structure would somehow have a negative impact on the neighborhood, notwithstanding the fact that it's permitted because it doesn't look like a residence. So since houses of worship are permitted, I'm having his own witness substantiate whether or not other houses of worship typically would look like homes. So again,
Let's give us an example of what house of worship you're referring to.
no, again, generally speaking,
I
as an
think-
architect, and you are an expert in architecture, are you familiar with architectural design of mosques?
Well, visually from the outside,
I'm
yes.
gonna,
Do they
the
visually
witness cannot
appear
answer that
similar?
question unless he's directed to the particular zone and area where a church is located.
You know, he's a registered architect in the state of New Jersey. She's asking him, do you know what a mosque looks like? I think he can answer that question.
The answer is yes.
And so, are you aware of any mosques that look like single-family homes?
I'd have to say no.
Are you, well, that's enough, thank you.
Your next witness?
I have no further questions.
Your next witness?
They call my traffic consultant.
Thank you, Mr. Wright.
I'll shake your hands afterwards.
But the front is gonna stay the same. The front looks counts.
Will you state your first and last name, please?
Lee, middle initial D as in Daniel, Klein, K-L-E-I-N.
Okay, Mr. Klein, do you affirm to tell the truth, the whole truth?
I do.
Okay, and have you testified, you may have a seat. Have you testified before the board previously?
I have not.
Okay, can you tell us about your credentials?
I'm a professional engineer in the state of New Jersey. My license is current and in good standing. I'm also a nationally certified professional traffic operations engineer, and my certification is in good standing. I'm the principal of Klein Traffic Consulting of West Orange, New Jersey. Been in business since 2013 on my own. I also provide traffic engineering services to a handful of boards throughout New Jersey, and I've been admitted as an expert in traffic engineering and parking analysis in well over 100 boards throughout New Jersey.
Okay, so unless there's any objections, we will accept. Mr. Gazarovski?
Okay, thank you. Mr. Klein, you were retained by me to provide engineering or a traffic review study concerning this property, were you not?
By the Adayas and Mr. Seller.
Okay, fine. Did you have occasion to visit site?
No, I've looked at it on Google Earth and Street View.
Okay. Now, please tell the board before you proceed, what exact steps you take in preparing yourself to provide testimony this evening?
I reviewed several documents that were provided to me by my client. The police department's report of April 7th, 2022 by Sergeant Martinez. The Board of Fire Commissioners report dated April 4th, 2022. The traffic impact and parking assessment dated March 25th, 2022 by Dynamic Traffic. The site plan dated 9/23/19, revised 5/7/20, prepared by Dynamic, and I believe I've seen other updated exhibits on the Zoom meetings in the past. Architectural floor plans dated November 19th, 2021 by MMA, and I was also present at the Zoom meeting on June 23rd when Mr. Taylor gave his testimony.
Okay, so you reviewed all of the existing documentation that relates to the site.
Those documents that I just mentioned, yes.
You've determined the number. You've determined the number of parishioners or congregants who can attend the synagogue and mikveh services.
I'm not sure I understand your question.
You're aware of the number of congregants who will be attending this facility.
I'm aware of the number of seats that are being proposed
Right.
in the facility.
And you have
550 seats.
550
Yes.
seats, okay. Now, with regard to existing conditions, what existing conditions are present that would affect your analysis of the site?
So when I look through some of the reports, particularly the police and the fire reports, I noticed that they have concerns about parking, circulation on the streets. So I just want to point out a couple of things that Sergeant Martinez said in her report, that there are other special events that could occur at this proposed synagogue with the
You know,
I have to object to
yeah,
the
you can't tell us
offered
what.
testimony from Sergeant Martinez. That is part of the record. My traffic engineer testified to it, and there's been stipulations that there are no special events, unlike Mag and David, which is what Ms. Martinez was testifying to. So again, if Mr. Klein is here to offer his wisdom as an expert traffic engineer, I'd ask him to do that, not to reread the sergeant's letter.
The sergeant's letter is a part of this record.
Right, but it's a report. We cannot cross-examine it. We would have asked her, do you understand that these events will not occur here? Would your opinion be the same? But nobody asked her that. So I'd like to hear his report.
If her report is a part of the record, and her report is a part of what he based his opinion upon, why can't he refer to that in his testimony?
Well, all right.
My objection is not to him referring to it or offering his expert opinion on it. My objection is to him rereading it.
And saying it's his opinion.
Correct.
Okay, so once again, you're saying that Sergeant Martinez's report is a part of the record.
It is part of the record.
And it's also evidentiary with regard to this matter. I mean, that's going to be, her report is going to be considered in making their determination, are they not? It's evidentiary,
Yes,
correct?
correct.
Okay. So if it's evidentiary and it's in the record, why can't he comment on it?
Comment on it, yes, but he can't repeat it. Why is he reading it?
Well, if, rather than beating this to death, was the report prepared by Sergeant Martinez a part of the materials you reviewed and also focused into your opinion as well?
That's correct.
Now, did you also review the potential capacity of people in the basement of either the existing synagogue, which is there, and or the new synagogue, which the witness has stated and given testimony saying there will be a specific, I trust, a deed restriction in there prohibiting the utilization of the basement and the, correct?
That was what was offered by the applicant, yes.
Okay, now did you also make a determination as to whether this entire building was ADA accessible?
No,
Pardon me?
it's not my expertise. No.
Okay. Now, did you look at the different parking layouts and the quantities of parking spaces in the layout?
I looked at the site plan. They're proposing 39 parking spaces. They're required 275 parking spaces, I believe, based on the number of seats. And I know that there are other holidays, other events when driving is permitted. And on those types of either events or holidays at the facility, that there'll be additional cars that will want to drive to the facility. So what I did is I looked at the street, Old Farm Road, around the loop, and measured that and took out for fire hydrants, stop signs, driveways, and came up with a capacity of about 140 cars could park on one side of Old Farm Road around the entire loop. And that's approximately from the farthest point of the loop, about a half a mile to the facility, and in the other direction also about a half a mile to the facility.
Now, Old Farm Road presently is the road upon which that vacant lot, known as lot number 3, phases off on. Is that not correct?
I'm not sure which lot you're referring to.
Lot 3 is presently the vacant lot where the mikveh shall be constructed.
Okay, yes, yes.
So at present, other than people who would park on Old Farm Road to walk to the Minion, the size Minion on Larchwood, is relatively little traffic there. Would that not be so?
I'm not sure I understand your question.
Well, right now, we have the existing Minion, which is located on Larchwood, correct?
Correct.
And now we're seeking to construct an additional
This is wrong.
synagogue
I don't know.
of additional thousands of square feet, which greatly increases the need for vehicles and foot traffic as well.
Correct. The facility's going from 228 fixed seats to 550 fixed seats. That's about 140% increase in the amount of fixed seats in the facility. So pedestrian traffic, I would anticipate would increase by about 140%, and as well as any other driving holidays and things that people can drive, the volume would be increased as well.
Now, did you make any observations as to whether or not there are any sidewalks on either Larchwood or on Old Farm Road?
There, for the most part, there are no sidewalks at all on Old Farm Road. There's a little piece of sidewalk south of this location on the east side of Larchwood.
One would have to assume then that in addition to cars traveling on Old Farm Road, anyone who is walking to the synagogue on Old Farm Road would have to be walking in the street itself.
That's correct. Or on the grass.
Now, you also are aware of the fact that the applicant had presented an exhibit showing the area which would be serviced by this synagogue, are you not?
Correct. Yes, I remember that.
Now, you're also aware of the fact that there are other synagogues located within the radius shown by the applicant.
I believe I've seen an exhibit that shows there are 2 other synagogues, I believe, within that same 0.6 mile radius.
Now, with regard to the actual travel speeds on the roadways in questions, do you know what that speed limit is?
Larchwood, I believe, is 25 in certain sections, and it becomes 35 if you go further north.
Okay, so during the times when services are being conducted, any of the congregants who are going to the synagogue itself necessarily would have to be walking in that street with those posted speed limits, 35 and 25 miles per hour.
Correct.
Right? Does that make any sense to have traffic traveling on those roadways at that speed and the number of congregants who are going to the synagogue walking in the street? Where else are they going to walk?
There are no sidewalks, as I said before, on the west side of Larchwood. There are no sidewalks within Old Farm Road. And yes, if a person was to walk to this location from anywhere except the southeast corner of Larchwood, and I remember the name of the street, but they would have to walk either in the shoulder or in the street.
Now, with regard to that street area of Larchwood, Did you also make any determinations as to the lighting which would be present on that street? Is there any street lighting present?
I don't recall.
Now, with regard to the numbers, as I read them, we're talking about approximately 550 people walking to the synagogue on high holiday service. How are they going to walk there other than in a publicly traveled street?
That's how they're going to get here. They're going to walk either in the shoulder or in the travel lane, depending on where cars are parked and where they're able to walk.
Okay. With regard to the parking which is located on site, approximately how many parking spaces are there on site?
They're proposing 39.
Okay. Now, based upon the number of congregants who are attending, where are those people who are going to be going to the services park their vehicles? As I understand it, you can drive to a service at a certain time and then leave your car parked there, can you not?
Before this Shabbos, people can drive there on a Friday, park their car, stay for the service, walk home, come back Saturday morning, stay for the service, and then leave after sunset on Saturday.
And that would be on Old Farm Road, because there's no parking on Larchwood, is there?
After the 39 spaces on site are filled, yes, that they would have to park onto Old Farm Road, because
So we're talking about possibly well over 100 cars looking for a parking space on Larchwood.
I don't know if that's going to be every Shabbos. I'm saying there are other holidays when people are permitted to park, to drive their car, that those other holidays, I'm concerned that there'll be more than
So
100.
when we're talking about holidays other than Shabbos where people are permitted to drive their cars, despite the fact that there's a provision for under 500 people attending those services, there's only parking for 39 cars.
That's correct.
Even if we put 4 people in a car, that's nowhere near satisfying the parking requirements, is it?
Correct.
And this is the relief that the applicant is seeking.
Correct.
What other reports, did you have also occasion to review the traffic report of the applicant's traffic engineer?
I did.
Do you have any comments to make with regard to that?
Just that the traffic report concentrated on the fact that the facility will only be used on holidays and the Sabbath when people are not allowed to drive. The only time that people would drive to the facility would be for small events like a bris and so forth, where they believe that 39 cars would be accommodated within their 39 space parking lot.
Well, isn't that just self-evident that the 39 parking spaces are nowhere near sufficient? You understand the question?
No.
In other words, you're saying that there are days when people would be able to drive their vehicles to the facility,
Yes.
correct? And based upon the number of seating arrangements and the square footage, what would be the required number of parking spaces located on site?
275.
And they have how many?
39.
Would that not necessarily mean then that they must park those cars on residential streets located throughout the area?
That's correct. And Old Farm Road is a 30-foot wide curb-to-curb road. If parking were to be on both sides of the street, you'd have a 16-foot travel way in between the two rows of parked cars. I know that from the fire code official's memo, he'd like to see a 20-foot fire lane on site. So I got to believe that a 20-foot fire lane along the streets is also something that would probably be required. If not, I would recommend that, so that when traffic is traveling in two directions and a fire truck is trying to get through and any emergency vehicle is trying to get through, they'll be able to pass. So parking on one side of the street and two travel lanes.
Is there anything further you wish to offer in your testimony?
I did some research on the New Jersey Department of Transportation's website. I found traffic counts, 24-hour traffic counts in both directions on Larchwood Avenue between Old Farm Road and Park Avenue. One of them was from Monday, April 15th, 2019. The other was from Thursday, until Thursday, April 18th, 9 a.m., those 3-day period. And then I also found some data from September 7th, 2016 through Friday, September 9th, 2016. And the average annual daily traffic that the DOT calculates for the street back in September of 2016, the average annual daily traffic in two-way direction on Larchwood was 3,382 vehicles per day. And in 2019, April 2019, it was 4,138 vehicles per day in two directions. That's a 22% increase over a 2.5-year period. I think that's all I have.
Got anything further you have?
No.
I have no further.
Mr. Klein, did I hear you correctly that you did not visit the site?
That's correct.
So you're not familiar with the practice of the congregants going to and from the synagogue during Shabbat and or holidays?
I did not observe that.
Okay, and you had indicated that it would not be safe to park on both sides of the street on Old Farm Road. Is there signage on Old Farm Road that indicates that you can't park on either side of the street?
No.
And if someone on Old Farm Road were to have a party and invite 200 people, would there be anything that would prohibit them from parking on both sides of the street?
No.
You had indicated that you had a concern that there are no sidewalks on Old Farm Road and on Larchwood Avenue and in the vicinity. Are sidewalks part of any requirements for this use to be in the neighborhood that you're aware of?
Not that I'm aware of.
And typically, who's responsible for installing sidewalks?
The township or the county?
So if the township or the county or the sergeant that you referenced thought that sidewalks were necessary because there's an unsafe condition, it would be the municipality's responsibility to install those sidewalks.
Agreed.
And you indicated that you didn't observe any of the walking currently. You are correct that currently the congregants do walk in the street or on their private properties. And is it your testimony that that's not a safe condition?
I'm saying that the increase in the amount of pedestrian traffic based on the increase from 228 seats to 550 seats is going to be an increase of pedestrian traffic on the streets, additional traffic of pedestrians, additional conflicts with vehicles. I can't predict how that's going to go, but
So it's your guess that it's a safety problem. You don't know for sure and you're not offering extra testimony in that effect.
correct.
Okay. And were you here for the testimony where there is a tent set up outside for the high holidays, and it's up for Rosh Hashanah and Yom Kippur, and it hosts, I think, about 500 plus people? Were you aware of that?
I heard that in testimony, yes.
And during that time, are you aware that congregants cannot drive?
That's correct.
So how would those congregants, all 500 of them, get there?
Would have to walk.
So did you reach out to the West Long Branch Police Department or the Ocean Township Police Department and ask for all of the accident records that were available to see if there had been any pedestrian-related accidents over the last 3 years, which is what I don't understand how long they keep them.
No, I did not.
So you're not aware that there have been no accidents?
Correct.
Okay. You indicated the only place that there is to park if there was an event, contrary to what was testified to, would be on the areas you measured minus the fire hydrants and the no parking areas, and it would fit about 100 cars. Is that correct?
140, if I said, yeah.
Were you here for the, you had indicated you're familiar with the exhibit, which indicated that just in a 3/4 of a mile radius of this location, there are 277 homes that belong to congregants.
I believe that's the number.
Okay. Did you do an assessment as to the vacancy of parking spaces on those driveways?
No.
So is it possible that if there was an excess of people and there was no parking, that they could go to a fellow congregate's home and park their car in the driveway and
You
walk
object to
along
that,
the
correct?
congregate?
Purely speculative.
There was speculation as to where these people are going to park. I have every right to ask him to speculate as to other possible
I'm going
locations.
to make my objection and ask for a ruling from Mr. Steinberg.
And your objection's noted, just, please answer the question.
So if,
So repeat the question.
277 homes, just assuming that it's a one-car driveway, and you're familiar with the area and the general demographic it's typically a much larger driveway. But even assuming most conservatively a one-car driveway, it's possible that there would be 277 spaces just the way they're quoting now.
It's possible, yeah.
And you had indicated that there are other holidays where there'd be large gatherings where people can drive. What other Orthodox Jewish holidays can people drive to services?
I believe Purim, Tu B'Shvat, I'm not sure, and there are a couple others.
And has there been, are you aware of an issue where there have been excess cars that could not be parked on the property or in the surrounding property? Not what you're told, are you aware of it?
I am aware of it by being told.
So you didn't observe it yourself?
Correct.
So you don't know how many cars and you don't know who they belong to, and you also don't know whether or not any of those homes were holding their own Purim festivals?
Oh, I don't know if it was even Purim. I don't think it was Purim. I think it was a Chinese auction or something. Yeah, I don't think it was a holiday.
So you don't have any empirical or personal knowledge of any parking issue over the last 9 years that the synagogue's been operating, oftentimes with as many congregants as are proposed now?
I object to the question. There was never any testimony that a number of congregants going to the synagogue presently will be similar to that going when.
I think there was. They had testified that they're hanging from the rafters, and it's not.
And on the high holidays, there are more congregants than there are seats currently proposed in the synagogue. So again.
There was testimony to that effect.
So again, you're not aware of the last 9 years of there being any parking issue that you observed yourself personally?
Not that I've observed myself personally, but from what I've been told by my client.
Okay. And, okay, that's all I have. Thank you.
Any redirect, Mr.
I have no redirect.
Board?
Questions from the board? No questions?
No, I'd like to ask a question, Mr. Steinberg. You know, we've been going through this issue of, for example, reports of Officer Martinez and the like. They are all part of the packages before the board, correct?
Yeah, and the board should consider all of those reports in their deliberation.
I'm fine with that. Now, having said that, could they also then be a part, if in fact this matter goes to court, those reports can be referred to as they're part of the record of this application?
Absolutely, and in the event that this would go to court, the entire file is given to the court, and all of that is in the file.
Right. So assuming for the sake of argument, reference was being made to a report prepared by Officer Martinez or others, they are in the record, they are evidentiary, and can be a part of any argument being made before a Superior Court judge.
Yes.
Thank you. While I'm doing that, and I've looked at my list of exhibits, and I know that you have excluded some of them from testimony this evening, but for example, notice of hearing for the application in 2013, that's part of the file in this matter.
No.
It's not?
It's part of the 2013 file.
And you're saying it's not a part of this file,
No.
even though it was referred to in testimony?
That was not referred to. What was referred to was the resolution which granted the approval, which was loosely based on that notice. I don't know if it followed the notice in totality.
With regard to the, for example, the property use agreement that was executed between the parties restricting the use of the property, you're saying that's not a part of this record?
It is part of this record.
Part?
That's part of this record.
Okay.
That's in our packet.
That's correct.
Yeah.
With regard to the resolution of 2013,
In the
that's
packet.
part of the record.
In the packet presented to the board. Because the application is to,
I was required to submit it as part of my
right, and the
That's
application
fine.
is
Look,
to amend
as
some of
long as
those
I'm
conditions.
comfortable that the questions I'm asking, you're responding as you are. I'm comfortable with that.
Yeah,
okay?
well, it's part of the record.
There's also reference to the modification of the property use agreement that was signed by Mr. Cohn and the applicant. That's part of the record.
Part of the record.
The notice of hearing for the application of 2022, that's part of the record.
For the record, it's in our file.
The engineering report that was prepared by Mr. Fitzgerald, dated 2018, that's part of the record.
No, it's not, because when this application became available, we had new engineers, and that report was not circulated.
The Fitzgerald report was not
Fitzgerald was not circulated, or
Could I?
18,
No.
2018?
Yeah, it was different
Yeah.
application.
Withdrew that application and applied for a new application.
Okay.
So
The 2018 report,
with regard to the new application, the engineering report prepared by that was prepared by the new engineer, not by Mr. Fitzgerald.
That's correct.
right here.
And similarly, the review letters of Mr. Higgins, which were dated for the 2013 application, are not part of the record.
Not part of this record.
Yeah, the only thing part of this record as far as my report goes is my June 14th, 2022 report.
Let me
Okay.
just check.
Let him go down the list.
Okay,
yeah.
okay.
So we don't get into an argument later
Yeah,
on down the
okay.
road. There was also a review letter that was prepared by Mr. Higgins in 2018. That's not part of the
Not
That's
part of the
not part of
record,
the
that
record.
application was withdrawn.
That was on an old application, it wasn't on this application.
Okay. Now, there was a Ocean Township traffic survey review letter by Todd Gregory dated January the 9th of 2020. That is a part of the record.
No, that's not part of this application either.
This application was submitted in the beginning of 2022, I believe. Anything before, prior to that date, that doesn't apply to this application.
The traffic safety review letter of Sergeant Martinez is dated April the 7th of 2022. That's part of the record. The review letter of CME dated June 7th of 2022 from Bennett Matlack, that's a part of the
Part of the
record.
record.
And the earlier review letter of Mr. Fitzgerald dated 2020, that is not a part of this record.
That was not this application. It was a prior application that was withdrawn.
But the applications were similar, if not
I have no
identical.
idea. I didn't review that application, never came in front of the board.
Similarly, the review letter of CME, which is dated June the 7th of 2022, is a part of the record. Correct?
That is, because that's this application.
Okay. With regard to the fire marshal reports of Mr. Flanagan dated April of 2022 and June of 2022, they are part of the
No
record.
part of this application, yes.
Correct?
Both of them.
Okay, let me call, if I can, please, Ms. Padilla back to the stand.
Okay, but just to, Mr. Gazarovski, we're at a minute, or an hour and almost 10, so I want you to be timely,
Timely.
please.
How much timeliness do I have left?
About 20 minutes.
Yeah.
What?
About
About 20 minutes.
Can you try?
Let's go.
Okay, thank you.
Can we subtract
We did.
We did, but we
all of the
did.
objections that Ms.
Oh, no, we're not going
Yeah,
there.
Much too late.
We're not going there.
Let's get Ms. Adea.
Ms. Padilla, correct?
Yes.
Yes. And I believe you're still under oath?
Yes.
Okay.
Okay, Mrs. Sadea, when we were preparing for this particular hearing, I went through with you many of the reviews and reports that were referred to in my conversations with Mr. Steinberg.
Yes.
Okay. And you recognize and understand that with regard to the ones that we have checked, he has stated that they are part of the record. And if in fact this matter were to proceed to a court of law challenging whichever way this decision goes by the board, those reports can be referred to and made into as exhibits at that time. Is that correct, Mr. Steiner?
Yes. Yes.
That's an affirmative?
Yes, that's an affirmative. Yes, yes.
So,
Say
having
that
said
anyway.
that in many ways eliminates a part of your testimony, okay? Now, also, when we were preparing for testimony, you had said to me that with regard to the 2013 application, you had prepared a narrative report which you intended to read into the record, or had read into and sent to the board. And I'm assuming now that with regard to that 2013 narrative of Mrs. Zedea, that cannot be a part of this application as far as you giving testimony.
No, but she's welcome to give us her opinion narrative now as to this application and this expansion.
Okay. Now, having said that, and we'll get back to that in a second, did you also prepare a narrative of your concerns with regard to the present application?
Yes,
You have a copy of that with you?
yes.
Yes, see that, please. Okay. Now, could you give us the date of when this statement was prepared?
Yesterday, August 17th,
Okay, in the year 2022?
22.
Okay. Rather than lead you through this step by step, I would request that you be permitted to read it into the record.
No problem.
Just one point of order. As she's reading this into the record, this is her testimony, which I can cross-examine on.
That's correct.
Yes.
Yeah.
Saying.
Stephen and I moved to 7 Old Farm Road in February of 1991.
And I should caution you also, read very slowly.
Okay.
Because if you're going to read quickly, the board's not going to be able to follow you.
Okay. Stephen and I moved to 7 Old Farm Road in February of 1991, 3 months before the birth of our third child. We already owned a property directly across the street, 4 Old Farm Road, but felt that building would take time that we didn't have, as we already had 2 toddlers under the age of 4. With Hashem's blessing, our family grew, and we celebrated.
Well, excuse me, everyone. Everyone deserves their time, please.
I don't understand what the last is about.
No, we have a point of order, please.
What?
For a point of order, everyone deserves their time. Please, everyone, respect.
If I may, I'd like to have this up while I speak.
Well, we have to
to
verify
mark it.
what it is. I don't know what it is. Well, you don't have to tell me. She has to tell me.
We'll get to that, okay?
I'll explain it in my testimony.
Until the board has ruled on my objection, I guess.
No,
We'll take it down until we put it back up there.
With Hashem's blessing, our family grew and we celebrated many occasions in our home. Brisses, bar mitzvahs, and sebbets. I would be remiss if I didn't mention the July 4th barbecue that grew in size year after year and resulted in several new friendships, engagements, and weddings. Our home was open to all, strangers and friends alike. Old Farm Road was and continues to be an amazing place to live, among wonderful neighbors that are also friends. Our kids felt safe to visit one another because everyone looked out for each other's family. The Old Farm Road Circle was the year-round place to be. To that point, a minyan, which is a quorum, was formed one winter to facilitate a community member to recite the mourner's Kaddish without having to walk in the cold, dark winter months to shul. People took turns hosting the minyan in their homes on Old Farm Road for many years to everyone's satisfaction. As some of the original families moved out, new families arrived. In 2013, an opportunity arose to acquire a house located at 48 Larchwood Avenue for the purpose of hosting the Old Farm Road Minyan. Hence, the Larchwood Minyan was born. In order to be granted permission by the Zoning Board of Adjustment to use the facility as a house of worship, a conditional use variance was necessary, as this is an R1 zone, which permits one single residence per acre. It's important to note that planning and zoning laws are in place to protect every township resident. The applicant made specific promises as to the use of the newly formed Larchwood Minyan. Examples of these are that it would only be used on Shabbat as well as holidays. Therefore, cars would not be necessary and traffic would remain minimal. Additionally, the facility would not be used as a venue hall for events. Therefore, a parking lot was not necessary. Many other stipulations were put in place that reinforced the minimal use so as not to alter the tranquility of the neighborhood. In addition to these restrictions, which were incorporated into a final resolution, an agreement was drafted by the applicant and their attorney promising to adhere to their sworn statements. That contract was signed by the representatives of the newly formed Minyan and ourselves. In 2013, we had concerns about the traffic, noise, garbage, and safety of our block. That's when the threats began. In addition to intimidation that came our way, my children received phone calls warning them of the consequences should their parents object to any plan submitted to this board. I cannot imagine that the congregation condones pressuring anyone's family into silence.
Permit her to continue her testimony, and the board will accept it or not accept it and deem it appropriate as they deem fit. Continue.
Thank you. When we signed the contract, we fully expected the threats and intimidation to stop. We expected the applicants to honor their commitments. We were wrong. Pressure was and continues to be placed on my children and grandchildren to get to me. Ironically, the shul is operating because we did not object to a house of worship, especially not this one, as has been alleged by the other signatories in the contract. Both are part of a recorded resolution and are a binding legal document in the Freehold Municipal Records. My position on the expansion has been grossly misrepresented in our community to the detriment of myself and, more importantly, my family. Pressure and intimidation was and continues to be applied to get us to void the agreement and to waive our rights. It is incumbent that every single tax-paying resident be afforded due process to uphold the very laws that are in effect to protect each and every one of us. We live in a country with a judicial system. I refuse to believe that my community would condone such type of behavior by anyone towards anyone. We cannot imagine, in fact we are certain, that the majority of the congregation has no idea what is being done in its name. We harbor no ill will toward them. We are not opposed to any shul. We are vehemently opposed to the use of pressure and coercion being applied to anyone in the name of religion. The following is an example of the threatening tone of the applicant. An email was shared with me by a neighbor, and I quote, "Emily hires a lawyer again to fight the shul. This time it will have serious impacts to her and her family."
Finish her statement. I'm allowing her to make a statement, and the board will weigh its decision later. Your objection is noted. Let her finish.
Thank you.
May or may not be relevant. Permit her to finish.
Emily hires a lawyer again to fight the shul. This time it will have serious impacts to her and her family. She is just who she is, and I have no problem fighting with her this time, but like I mentioned in my previous email, it will have a broad impact on her. Upon my father-in-law's passing in February of 2021, my husband began attending the 7 a.m. minyan in order to say Kaddish, the mourner's prayer, in a quorum. It is mentioned in Mr. Mastery's opening statement as being open to all worshipers. On the morning of July 16, 2021, immediately after the conclusion of prayers and after the others had left the sanctuary, Stephen was confronted by both Mark and Isaac Mastery. They stated that if he was going to hire an attorney to object at the zoning board meeting, he was told, "We allowed you to come here. You are no longer welcome. Pack your things and get out." I cannot imagine that the congregation supports intimidation, humiliation, and bully behavior. We have expressed many times that we do not oppose the expansion of the synagogue. Unfortunately, that expansion is being held hostage by grand plans. I do not trust the current leadership not to honor their commitments and not to stop the threats, but I am confident that with responsible and ethical leadership, the synagogue expansion will be supported by all, especially by me. I'd like to put that up now.
Just describe what it is.
I will. It's actually in my next testimony.
What is it?
Pardon me?
Before you on this poster board is a photograph of what is on display in the lobby of the synagogue since June 24th. Ironically, it is next to the Tree of Life. Its sole purpose is to attempt to intimidate and shame us into withdrawing our objection and voiding our agreement. In addition, an email was sent out to all the congregants that it is the applicant's, and I quote, fiduciary responsibility to notify them of our suit, end of quote. I cannot imagine that the congregation condones the deplorable use of scare tactics against anyone, especially a neighbor and a congregant. My family, the congregants of the synagogue, and this board have been deceived. It is my hope that the truth will prevail because principle and dignity are priceless. Thank you.
Let's label that as 01.
Let's have her identify what.
Well, she did identify it. She said she took a picture of the lobby in which the board is up showing the lawsuit that she filed. Yeah, but let's mark it as 0. Okay. Well, questions about that exhibit?
I did. I believe it was July 3rd. I have it in my phone. It might have been August 2nd or 3rd or 4th. Somewhere. 2022.
And does it say anything derogatory about you, or does it just show the lawsuit?
It just shows the lawsuit.
In your opinion, if you're a member of the organization that's being sued, do you have the right to know you're being sued?
Yes, absolutely.
So it shouldn't be kept a secret from the congregation?
Absolutely not.
Thank you.
We can mark that as 01.
Before we go further, Mrs. Dyer, with regard to this document, and what you read into the record, you have this reflected in a written document, do you not?
Yes.
Now, tell me, anyone, if anyone, assisted you in the preparation of this document?
No one.
Did you consult with your attorney, or did he provide you any advice or guidance with regard to what you should say in this document?
No.
This is your document.
Yes, it is.
Pardon me?
I don't think she's finished with her testimony.
Did you conclude? I'm sorry, I had a
I
question.
didn't conclude yet.
What is this?
Now, Ms. Adalia, you prepared a similar statement, did you not, with regard to the application that was before the board in the year 2013?
Yes, I did.
And many of the statements that you refer to in that narrative are similar to the ones dealing with the updated statement for the year 2022.
Yes.
Just so we're clear with regard to a basic tenant in this case, you have no objection to the presence of a minion on this site as was applied for and approved in 2013, so long as the applicant adheres to all of the conditions and restrictions which are reflected in the property use agreement, which was signed on July the 31st of 2013, as well as the resolution that was incorporated, that resolution, on September the 12th of 2013.
That is correct.
Now, to your knowledge, was that agreement with those restrictions recorded in the office of the clerk of Monmouth County?
Yes, it was.
Was that agreed to by the applicant?
Yes, it was.
Was it signed by him?
Yes, it was.
Was it signed by you and your husband?
Yes, we both signed.
Okay, now, when you executed that agreement, did you have the advice of counsel?
Yes, I did.
When that agreement was executed by the Masries, did they have the advice of their attorney, Peter Falvo?
Yes, they did.
In your mind, was that the end of the ballgame with the story, so to say, with regard to the utilization of this property for religious purposes?
I believe so, yes.
Now, prior to the applicant coming in with his new proposal or new application, did he ever consult with you with regard to his intention to increase the size of this activity?
Yes, he did.
And what was your response to him?
My response was that I still did not want to have a parking lot or a social venue or anything else.
Okay. Now, with regard to this sale of, I think it was Lot 4 in question, to the, can I finish my question?
I can place an objection on the record, Mr. President.
You don't know what his question is yet,
No,
just
he's
wait.
referencing the agreement and the sale, and you've already ruled that the legal efficacy of that document is not for the purview of the board.
But
it's the
he's
purview of
beyond
the
that.
court.
He's beyond that. He's now asking another question about
Yes, about
another.
the sale of, okay.
You're a day late and a dollar short.
I'll bet you $100.
Now, also, at a given point in time, I'm going to refer to Exhibit 4, which is a ratification of a property use agreement with regard to lots 3 and 33, that is executed by Sam Cohn, Susan Cohn, and Mark Massery. Can you look at that, please?
Yes.
Okay. Now, that deals with a modification of some type of restriction which Mr. Cohn was attempting to accomplish. Now, when you sold this property to Mr. Cohn, it was a vacant piece of property, was it not?
That is correct.
At the time you sold it to him, you owned another parcel of land nearby to the subject application, and that was owned by you, correct?
Yes,
Now, if either you and or your husband signed this modification agreement, which is dated October the 21st of 2019.
no, we did not.
If we're going to the legality of the modification, A, it's nothing for the board to make a determination on, because those agreements are binding between individuals.
Yes.
One. Number two, it's the subject matter of your litigation that's before the court. So the court will make that determination of whether or not that can be, is a valid document on whether it can supersede the prior agreement. This board does not have any jurisdiction to make that decision.
Yeah, but the board, the applicant's coming before this board saying that none of those restrictions apply to them.
No, he's just telling us that the applicant has indicated that there's been a change. You say there hasn't. Even without all that, all the board needs to do is make a determination of whether or not the prior restrictions can be removed and the property expanded.
This board can't make that decision.
This board has the jurisdiction to determine whether or not certain conditions can be lifted.
Of the resolution.
The resolution of the application. If you have a written document between the parties that supersedes that, the court will tell us that we did wrong. But this board can't decide that.
Would you say that again, please, so I could follow what you're saying?
So this board has the jurisdiction on any type of conditional approval to remove the conditions or restrictions upon application in a public forum, which is being done here. They're asking us to change those. You feel that you have a document that is still valid, and that is for the determination of the court.
This board does not have the jurisdiction.
Well, that's fine. I say the board can remove and decide upon conditions and whether or not those conditions can be lifted in the purposes of zoning. If you feel that these are restrictions that are mandated by written documents and cannot be removed, that's what your lawsuit is about. That's what you're asking the judge to decide. These are not judges.
So, just so we're clear, all right? Because I don't want to go back and forth.
Yeah.
You are also saying that if in fact this board were to approve this application, it would be subject to whatever a superior court judge decides with regard to the imposition of those deed restrictions.
Whatever we grant can be blocked by your court suit, yes.
And if in fact the court were to say those conditions must still be adhered to and applied to, this approval would be deemed null and void.
I don't know if it would be null and void. There would be part of an appeal process that if the board grants it, you can appeal their decision and include that in there. If the board denies this, then the applicant could say that those conditions are null and void also. So either way.
The applicant, if this application is denied, they can appeal that. But
Yes.
they cannot appeal as a part of this case the deed restrictions which are a part of and constitute the case in freehold in the law division. But two different things.
I missed the whole.
Madam Chair?
I'm getting beyond this now.
The applicant would offer that in the event this board denies it and an appeal was filed, we would join the two parties under the entire controversy doctrine. And whatever judge was hearing the appeal of the prerogative writ would also consider Mr. Gazarovski's arguments with regard to the agreement.
Which would be
It would
likewise
it
the
would
other
become
way.
one suit regardless.
And likewise the other way, if the board grants this approval and you appeal the board's decision, that would be part of the determination. It would all become under the single controversy doctrine. I agree with Ms. Grinko. Either way, those things are decided. This board only has to decide on the testimony that was submitted of whether or not there's a reason to adjust, basically, some of those conditions, because most of them still remain in full force and effect. Most of the conditions, they're not moving. Just a few.
If I can ask that Mr. Gazarovski, if John with his questions on it, with his direct examination, find out his questions.
I just want to go into this. The board has the jurisdiction to modify the conditions. If a court says otherwise,
The board has the jurisdiction to modify the conditions of the resolution of approval. It doesn't have the jurisdiction to modify the deed restrictions.
Okay, gentlemen,
Correct.
I'm sorry, but
Correct.
we-
Let it
we've
go with that.
legalized this ad nauseum.
Yeah,
Okay,
that's what the-
no. He's answered it 8 or 9 times so
The
far.
board can't change the deed restrictions.
Okay, so
I
The
don't,
board can't change deed restrictions as part of a contract with another party. The board can absolutely change the deed restriction that the board imposed.
yes, but there is a deed restriction here
I
that the
understand,
board
but-
imposed, that's fine.
Right.
We're only talking a couple of
I
small
know.
conditions that have to be
But
changed.
again, this hearing is now being turned into a lesson in civil procedure. I'd like to move on with.
I don't wish to learn. Can we please move forward?
Either way, yeah. Either way, that condition has to be, the deed restriction has to be dealt with. That court,
I have nothing further to ask.
I have some additional questions. Mrs. Adaya, you had indicated that you have lots of parties at your house for the July parties. Did everybody park in your driveway?
Not lots of parties.
Objection.
no.
Objection.
And there was testimony from the traffic expert that there's no place to park, and what if there's a big party? I
There
think.
was testimony from Mrs. Adaya specifically.
Valid.
There were gatherings at her house for brisses, for a 4th of July party that became a larger regular party. So again, with regard to.
How is that in any way relevant to this application?
Because if people park on the street,
Correct.
that's part of your traffic expert's indication. So
Okay.
it's a valid question.
Mrs. Hidayah, did everybody who came to your 4th of July party park on their driveway?
No,
Did some people park on the street?
some people parked on the street.
You'd indicated that you took the photo when you moved in as 01, which is recently as August of 2022. You are on the road, correct?
Yes,
I think she said July.
no, I think it was first week of August.
So it's August.
Start with July.
Yeah, okay.
How
Did
did
she
you
start
get
with
into
July
the
3rd?
synagogue?
Yeah, it was a
Locked it.
So you left the boat to get into the synagogue?
It wasn't locked.
Okay, what time of day was it?
I would say 11:30 a.m.,
What day?
Tuesday or Wednesday.
Okay, that's another question. Oh, and your concern is traffic, garbage, noise, and safety?
Among others.
What are the others?
The frequency of the traffic that would occur. A barbecue happens once a year.
You said there are others. I didn't ask for specifics. I'm saying traffic, garbage, noise, and safety. And there are other concerns that you have.
Yes.
What are the other concerns?
The level of frequency that the facility would be used by the amount of people that would use it.
Other than that, are those your concerns? Those are your questions?
Yes.
Thank you.
One follow-up question. When you executed this agreement back in 2013,
I have to object. Mrs. Hidayah was not a party to that agreement. It's part of the record. She's not a named party.
She is.
She signed it after the fact at the end. She is not listed as a party.
She signed it in
Stephen
the-
Hidayah is the only member of the Hidayah family.
Your
listed
objection
as a
is
party.
noted. Let her answer the question.
yes,
May I answer?
yes.
I believe my name is in the recorded resolution. Mine and Stephen Allen Hidayah.
I'm speaking about an agreement which is separate.
My name is also on the signature that was recorded.
Was it handwritten in or typed in it like the other
Handwritten.
signatures? Is your name listed as a party to that agreement?
I believe that it is.
It's part of the record, Madam Chair, and I would say that Mrs. Hidayah is not a party to that, and I'd ask the board to refer to that.
I have no further questions. I have no further questions.
You
I
want
want
to?
to recall very briefly, Mr. Jenner.
Oh, yeah, we,
The due process has been more than exhaustive.
How
But we-
briefly? How briefly?
5 minutes.
5
5
minutes.
minutes, Tom.
5 minutes.
Tops.
We'll give. And Shawanda, I think
I'm
you still
sorry.
under oath.
Yes,
You still
I
have-
recognize him under
I
oath.
know.
Yeah, thank you.
Thank you. Mr. Chairman, you earlier testified on this matter, did you not?
Correct.
Did you also read the transcripts when you're present this evening?
Yes.
Having said that, and based upon your prior testimony, do you have anything to add or supplement your prior testimony?
Normally, a planner gives a net opinion based upon the testimony of others. And so all I want to say is normally they go last. Because of accommodations for witnesses, I went first, and then I listened to everything else. And so nothing I said based upon the record tonight has changed in my opinion. That's it. Less than 5
Thank you.
minutes.
Less than 5 minutes. We appreciate it.
No question.
Thank you.
I have no further.
2 minutes. Yeah, there's still some, right? Yeah. An hour and a half, What?
Time for a solution.
Yeah, now would be your summation, and then Ms. Grimko's.
Well, plus open to the rest of the public.
Well, we'll open it to the public, yes. But I would request, Ms. Grimko, that your individual congregants and clients let you speak for them.
Okay.
I don't want to hear from everybody there. Okay. I understand. So, do you need a minute to gather your thoughts, or you ready to go?
Yeah, I'll have a minute to gather my thoughts.
Okay.
I'll take those 3.5 minutes that you use.
Okay.
I'll take one.
Would we request a 5-minute break?
Yes. We'll adjourn for 5 minutes.
You're going to sum up, and that's it. Yeah.
What's that?
You're going to sum up, and then she'll sum up. I don't know if you want to vote or not. It's up to you.
Good. I'm feeling good. How about you?
How are you? I haven't seen you since on Zoom.
Your application, make it brief. I'm just going to say everything I'd like to say.
This is it. We're going to get done tonight.
There's two more on, I just know which is which. Really? Have you ever been a lawyer?
These guys are short. I mean,
I gotta hit the men's room.
but this one, we want to go. I almost don't even know. She's, you know, I don't think we're. You know, it's I can't cut anybody off over here. You know, one hand, the other hand.
No, you're supposed to, if you have a comment, you're supposed to go to the mic. You will state your name and your address. Yeah, you just line up. You have to state your name, your address, and then.
Want me to make a statement or not?
No, I'm trying to see you.
I have a little 30-second statement.
What's that?
I'm against it.
Yeah, I'm going to let everybody comment. No, I said I wouldn't before Chris, the attorney. I'm going to. No, I'm going to because we're talking about Seaview. On Seaview. On Seaview, I'm going to let everybody eventually put their 2 cents in from Ability Crest. Ability Crest. But I figured what happens, always happens, is they all want to say something. And about 6 people start saying it, they will beat them out. We know that. So we're going to let them do that. Yeah. Tell Jen. So, yeah, okay. You have another objector. You represent a second objector. Okay. Let me talk to Jen, because we thought you're done.
Quick question.
I heard that.
Not question, comment. They can't ask.
My suggestion is that they get up and want to speak and say what they were having. Oh, that's right.
Then my last
Yeah. The fencing, they took the fence.
Yep.
There's no fence on two.
There's only fence on one side.
No,
There's a 10-foot wall on one
With the
side.
head-
The other side, no fences.
Yeah, there is like, on the other side, it's settled with.
That neighbor. The other neighbor, the fence.
The only difference I have is the nature of the fence.
I want to try to pronounce it.
Oh, no, we're not gonna.
There's also another.
No, we're done.
Put on the record.
Yeah, but then there's 2 more pieces. Oh, no, I mean,
A lot less fence. Oh, yeah. The only fence.
we're driving up to.
And then if she has a, if she disagrees with that, she can say something.
Good sit here.
So discussing, you have to understand something.
Well, what you're saying is, we're going to say,
She's proposing 75%. We're gonna make it 10.
For this, they're going Thursday night?
you have to,
Most of these are the same.
you're not using the stuff.
FYI, I think
Speak on their behalf.
Sorry, go ahead. Julie was next.
I have never been more fucking.
A better way to make a living.
That's all right.
Funny thing is, my daughter Alice, she was in college. I picked her up at the airport. I had to testify at Home. I couldn't get her home back and testify, so she came with me to the hearing at Home. Oh, yeah, yeah, absolutely, you're right, yeah, you're right, yeah, absolutely, yeah. So she sits through the hearing, I'm walking out, she looks at me and she goes, I don't know how you can do this for a living, I could never do it for a living.
See, that was.
I have a certain way about me. Just so I argue.
10 years ago, when I got started, there were some that.
This is it here. This is here. Everything else is gone. Yeah, that's all gone. Yeah. It's just the 10-foot high fence protecting this guy's shit. So overdeveloped. Yeah, that's gone. Oh, really? Yeah. Yeah, they're not putting anything, nothing there, no fencing.
No, I don't.
Okay.
Actually, the truth, I just don't want it. I think it's like it's
Yeah.
Yeah, that's what they They could say actually it goes beyond what's in the report.
and I will I hate this.
No, they have to, it's gotta be conditioned of approval. The revised plans get submitted.
Just the chances of having or something.
Right, I was just saying.
No?
What?
Oh, yeah.
Okay.
Okay, Amy, if you can please call the roll.
Yes. Sorry, here. Here. Here.
Here.
Here. Okay, Mr. Gazarovski, your
Thank
closing
you, Madam
statement.
Chairlady. Madam Chairlady, we went through the testimony of Mr. Hadai, and it slipped my mind that there were two objectors in this matter, the other being Mr. Seller. He wishes to make a statement which will take 2 or 3 minutes.
If you
Excuse
can
me,
state-
just one question. Ms. Krimko, we're having a difficult time hearing you with the recording. Would you mind using the microphone as we go forward?
Sure.
And if you can just state your name, your
Sure,
address.
my name is Joseph Seller. I live in Oakhurst since 1998.
But sure, you have
Oh.
to be sworn.
And,
I live at 44 Larchwood Avenue. I'm sorry.
okay, and
We
can
have
you
it?
raise your right hand? Do you affirm to tell the truth, the whole truth?
Yes, I do.
Okay.
Is that on?
Right.
Yes.
Yes,
It
you're
is.
right.
It's on.
They're all on.
It's on.
They're all on.
Yeah.
Okay. Simple statement. My name is Joseph Seller. I have lived in Oakhurst since 1998. with my wife Anna. I'm a practicing Jew, so I want to make clear that the opposition has nothing to do with religion. I moved away from Lakewood because of what was happening in the community in terms of synagogues, Chabads, just like this one, popping up all around us and taking what was once a very peaceful and quiet neighborhood into a constant activity, celebration, and chaos. It's no secret what happened to Lakewood. I don't want that happening in my neighborhood. As a son of a Holocaust survivor, I was always taught that when you make a contract or you give someone your word, you stick by it. However, despite what the written agreement was between the petitioners and the Hadayas, this feels like nothing other than buyer's remorse, rather than honoring a legal commitment. Part of what makes our neighborhood so beautiful is the quiet, the peace, and the lack of activity on our streets. We never would have moved into this neighborhood. Third, do I imagine others would if all had sudden, after 25 years of quiet? There are weddings, celebrations, music, massive amounts of parking problems going on a daily basis. I support my fellow Jewish brothers and sisters in celebrating with each other, but I would prefer them to do it elsewhere, not directly next door to me. Thank you for your time. I hope you will consider the facts and legalities of the contractual situation that existed before this issue arose.
No question.
Okay.
Thank you. Madam Chair, would Ron goes first. Thank you.
You guys, Russ, would you bring the microphone towards you, please?
Thank you for the time and attention that you have paid to this matter. I'm going to keep my comments very brief. I was, in fact, the attorney who represented the Hadayas back in 2013 when this applicant first came before the Zoning Board of Adjustment. At that time, they were represented by Peter Falvo, whom I believe is with the same law firm as Miss Krimko is. We sat down. My client was prepared to argue as vociferously in 2013 as she is now. Sat down in a room with the applicant and his attorney, and we came to an agreement as to how this property would be utilized. Now, normally, that is done oftentimes on a handshake. The applicant goes back before the board, tells them what he's agreeing to, and as you can see in this 2013 resolution, there were specific restrictions placed upon the utilization of the property. I was not satisfied with that because in listening to Mr. Masri speak and listening to the beginning of the presentation, I wanted something which I believed would be, quote, ironclad. In other words, if you're going to agree to do certain things, just don't tell me you're going to do it, but put it in writing. Now, those restrictions were incorporated into the resolution of approval in 2013. When you read that resolution, you will say that they specifically refer to the settlement agreement that was executed between all of the parties. The objector also, Mrs. Adaya, also signed that agreement, and both of the Masris, father and son, signed the agreement. They agreed to it being incorporated into the resolution of approval. They agreed and signed the document which had it recorded in the clerk's office of Monmouth County. It really doesn't get any more binding than that. Now, Mr. Steinberg and I may disagree with what this board has the power to do, but I do believe that what we both agree on is that this board does not have the power to make a ruling with regard to the restrictions that are in that agreement. Only a Superior Court judge has that power. But you do have perhaps you may have the power to take a look at this application and say, well, we are going to allow him to amend the application and expand the use. Well, when you look at that, and you look at what was there originally the property contained a single-family residential home along with some amenities which were on Larchwood. That's what was there. Everybody supported the utilization of that residence as a minyan. And it's been described to you by many, many people as to what a minyan is in the religious faith of Judaism. It's a very quiet, peaceful time for prayer, basically nothing else. Well, that is not what is going to happen on this property now if in fact you grant this approval. And I think we have to step aside from the emotion of it being a religious application. It's more than a religious application. It's going to be a part of the community, but it's not permitted in this zone. And they haven't satisfied any of their criteria for that. Look at the amount of cars that will be drawn to this site. Look at the amount of lack of parking which is on this site. Let's just look at this not as a house of worship, which is simply an application for a use which is a conditional use which requires the satisfaction of many of the conditions in your ordinance. It simply doesn't have that. I said I would keep my comments short. I feel unfortunately that this matter will in fact be decided at a later date in a court of law. Thank you for your patience.
Thank you. It's good go. Just wanted you to move.
I'm sorry?
Should I get to
Would
sit
you
back
mind taking
there?
the microphone?
Again, he's an objector, he's a member of the
No problem. Mr. Gazarovski.
appropriate for him to be at the applicant's table.
Okay, yeah, we'll handle it.
What are you talking about? What's she talking about?
She'd like you to sit in the audience.
Mr. Seller?
No, you.
Sitting in the audience?
We would like you to sit in the audience so that she could have the dais at this point. Not
She
the
could sit
dais.
right here. I'm not afraid of her. She could sit next to me.
Again,
Ron, it's her application. She didn't sit with you. Why don't you just step aside? Thank you.
before I offer my summation, I can stipulate to the board that none of the members of the synagogue will be giving individual testimony. They're relying on my closing. Their presence in and of itself is indicative of their support being here. Before I give my closing, though, obviously, we're all assuming that Mr. Gazarovski's two clients are the only two that wish to speak. Other than members of the synagogue, I'd ask the board to open this to the public. And if there are no other comments, I'd ask the board to close it to the public before I give my final statement, because as the board knows, in practice, the applicant gets the last word before the board deliberates.
No objections, right, Mr. Steinberg?
No, she's right. We're open to the public. Does anybody want to make any comments?
Okay, if there are members of the public, if you can please come to my right microphone, and you will state your name, your address, and you will give your comment. Yes, I'm sorry, your name and your address.
Alexis, Dow Avenue, Oakhurst.
Right.
First, I just wanted to state.
Ma'am, you have to be sworn in.
Sorry. Do you, please raise your right hand. Do you affirm to tell the truth, the whole truth?
Yes.
Okay.
First, I'd just like to state that the public should be able to attend these meetings remotely. It's a tad ridiculous coming out of the global pandemic that should become all of us work, that we don't have a hybrid option for a public that we're doing. And that I have to give up time to my family tonight, rather than watching on Zoom. Good evening, Madam Chair. And
So did,
for the
so
We all
did,
did.
so did our volunteers. But go ahead.
Good evening, and thanks for the opportunity for public comment. My name is Alex Hayes. I live in Oakhurst. I'm a proud Ocean parent of two children who are in our public schools here in Ocean, and I am also an elected member of the Township of Ocean School District. The obligatory disclaimer here, I'm speaking tonight on my own. I don't speak on behalf of the Board of Education, nor do I have the authority to do so. This is strictly me as a personal taxpayer with some expertise in the school district. I wish that the town and this committee and the school district and the school board administrators could meet a little bit more regularly and share data and strategic planning for and among all entities. I think that makes for a more cohesive government and town. As I have the right, I would like to give some testimony here. Again, these are my personal comments about the Ocean School District and how we lose money when we lose students. The ballpark enrollment in all 5 of Ocean's schools is around 3,200 students. And the township loses about 100 kids per year. This coming year has yet to be seen, but come September, I suspect that number's going to be higher. It's going to be more than 100 of a loss to our school district. Perhaps no more so than in the Oakhurst section where I live, where I personally know a half dozen families from OTES that moved out of town since May. These are lost students.
Excuse me, 1 second. The microphone is not picking up.
Hello? Oh, wow. As I was saying, I think we will have more than 100 loss of students this coming year. These are lost students. What we lose in money, however, as a school district is astounding. Since 2017, the district has lost a total of $1.7 million in state aid. From 2011, it has steadily decreased from approximately almost $8 million a year to $6.1 million this year. In the next 3 years, future state aid loss will be $931,000. In 2022 to 23, Ocean will lose $512,000. The following year, $320,000. The following year after that, 24-25, Ocean will lose $100,000 in state aid. And so that means in 3 years from now, we will cumulatively have lost 1/3, 34% of our state aid to our schools. That's $2.6 million that we will have lost.
Can I just object? It sounds to me this is a general comment, this is not a general comment period, this is only with regard to this application.
It does. It does.
Okay.
By law, the school district can only increase the local tax levy by 2% each year. So this said, we all know we have operating expenses that increase every year. We have a special ed department that has more resources and more students every year. ESL enrollment is also increasing every year. To balance this budget for the coming year without increasing our local school tax levy above the state max allowed 2%, our district has had to let go of several teachers, several staff, has had to cancel programs, stop the expansion of programs, and as many of you know, has decided to use some federal money on infrastructure instead of school programs, something I've been vehemently against. But these are the tough decisions we as a board have had to make when we have a cash-strapped school district that gets a once-in-a-lifetime influx of money. So why am I bringing this up? Because I have listened in this meeting and the last 2 meetings for probably over 7 hours of my time, concerned about the expansion of this site will increase the expansion future growth of the private schools in town. The private schools in town have grown in student enrollment, and as you know, after recently, they were granted approval to expand even more greatly. With the passing of tonight's expansion plans, I worry that the tax burden to residents for our public schools could increase. If our school district loses money from the state school aid, which is currently tied to how many butts in seats, if I can use the vernacular. We get money based on how many kids are in our schools. I worry that we may have to make the difficult decisions in the future, such as going above the 2% tax cap for an increase in school taxes. If we want to maintain the current amazing services that we have in the Township of Ocean, in our school district, but we continue to lose students and thus state funding, I believe the Township of Ocean School District is going to have extreme difficulty balancing our school budget without asking more from the town and taxpayers. That's it. Thank you.
I just can comment that I don't know how you relate that to this application.
It's fine.
Okay,
Just
Thank you. But
Thanks.
Are there any other members of the public with comments? Okay, seeing none, I will ask if there's a motion to close the public hearing.
Motion to close.
Second. Amy?
Yes.
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 Yes. Okay.
Thank you, Madam Chair. And before I start my closing, I just want to clarify a few things for the record and make some stipulations. The first one is, Mr. Gazareski in his closing indicated that this is not a permitted use in the zone. That is not true. The R1 zone conditionally permits houses of worship, subject to meeting certain conditions. So I just want to remind you, and you'll hear in my closing, this is a permitted use subject to conditions. Also in his closing, he was discussing the board's jurisdiction to modify an agreement between private parties. We are not asking the board to do that. We're not asking the board to take any action whatsoever with regard to a private agreement. It is the applicant's position that that private agreement has been modified by the successor in interest to the property known as Lot 4, which I think are 4 Old Farm Road. Again, this is a subject of litigation. It's something that a judge will decide. It's not for you. What we are asking you to do is amend conditions that were previously imposed on an application almost a decade ago. Some stipulations. There was a fire marshal's letter. Should the board approve this application, we can stipulate to comply with his request to widen the access driveway to the full 20 feet. It will not create the need for any further variance relief, and we would accept that as a condition. I wanted to point out that Old Farm Road is a 30-foot wide roadway, which under RISA standards does permit parking on 2 sides of the road. I'd also like to stipulate for the record that we did do the search and requested the accident reports for the last 5 years. Ocean Township only keeps 3 years, and West Long Branch keeps full 5. We got them all back, and there was not a single pedestrian accident in the vicinity of the synagogue, particularly on Shabbat and or any Jewish holiday where there were numbers of pedestrians walking on the street. So with all of that as an opening to my closing, and forgive me for some of the length, but this has been 3 full hearings, and I want to make sure that I wrap it all up. In 2013, the zoning board approved the conversion of a single-family house into a synagogue for what was then a small group of Orthodox Jewish neighbors with shared ideology who sought to pray together near their homes. As you heard through the testimony and saw with the As you saw through the testimony and heard, as you saw through the exhibits and heard through the testimony, at the time of the original approval, there were about 75 families who lived within 3/4 of a mile of the subject property. At the time of the original approval, and based on objections by the residents in the area, the synagogue agreed to certain conditions to the use if it were approved. They agreed because at the time the conditions that were imposed by this board were acceptable to them because they did not impact or impair their ability to exercise their religious practice. But more importantly, when they agreed to the conditions for that specific application that was sought at that time, they never agreed that they would not come back to the board at some future date and seek to amend those conditions, which is allowed to and contemplated by the municipal land use law. As you know, and as your board attorney told you, the municipal land use law and the cases that have been heard interpreting that have found that the board is authorized to amend conditions, including lifting deed restrictions imposed by the board, provided it does so at a public hearing with notice to the surrounding property owners of 200 feet and notice in the newspaper, and that the public and the interested parties are permitted to speak and offer any comments they may have in favor or against amending those conditions. That's exactly what we did here tonight and what we did the last 2 hearings. A lot has changed since 2013, and the needs of this community that this synagogue serves have changed also. As revealed through the testimony of founding board member Isaac Masry, a lifelong full-time Ocean Township resident, the number of families that the synagogue serves has grown dramatically. In the same 3/4 of a mile radius, the number of families who attend this synagogue has jumped from 75 to almost 300 families. With the increase in congregants, and many more of them being full-time residents now, the needs of the synagogue has also dramatically changed since 2013. Some of the conditions that the synagogue agreed to almost 10 years ago that were imposed by the board are now a substantial burden on the congregants' ability to practice their Jewish faith. The existing facility cannot fit the number of people seeking to pray there. As you heard, congregants are praying in overcrowded rooms, entryways, and hallways. And some can't pray at all since there are no seats available to them in the main sanctuary. So we filed an application to amend the conditions and allow us to expand the existing synagogue building and to construct a small 1-story mikveh building to allow the women of the congregation to fulfill their religious commitment and practice. The use itself, a house of worship and any accessory uses to it, are permitted in the R1 zone. They are conditionally permitted. What that means is that the use itself was contemplated and considered as appropriate for this neighborhood, subject to certain conditions being met. If all of the conditions can't be met, then the applicant is required to seek a conditional use variance from the zoning board, which is what we are doing here. Needing a conditional use variance does not make this a non-permitted use. It doesn't mean that it shouldn't be permitted. What it means, and as you heard from the testimony of not only our planner but the objector's planner, that the applicant needs to demonstrate that the subject property can still accommodate the use despite the variances. In other words, the board needs to consider the effect of the use on the board needs to consider the effect of the grant of the variances on the surrounding properties. This does not mean that the board should consider the effect of the use on the surrounding properties of the neighborhood, because the governing body has already rendered it an appropriate use in this neighborhood. The board's focus should only be on the impact of the conditional use variances and whether the grant of these variances will cause substantial detriment to the character of the neighborhood. The objectors and their professionals attempted to twist the issue by asserting their perceived negative impact to the neighborhood if this application is approved. However, what they failed to do is demonstrate that any of this alleged impact flows directly from any of the variances we are seeking. Every alleged negative impact asserted by the objectors is directly related to the use of a synagogue in their neighborhood and has nothing to do with the conditional use variance relief sought for this specific property. You heard the testimony tonight. The objections were admitted. Traffic, garbage, noise, frequency, and safety. Those are all attendant to a synagogue use. None of them are related to the size of this specific property. The purported traffic issue is wholly unrelated to the conditional use variances or standards, and more importantly, is admittedly by the objector's own witnesses, speculative and unproven. The size of the congregation is not proposed to grow. The number of people walking to and from the property is not changing. These individuals currently walk the neighborhood on a weekly basis and on holidays, to and from shul, to and from family members' homes, and to and from the homes of their friends. Yet, there has not been a single pedestrian-related accident as a result. Most importantly, not a single conditional use variance being sought has any relation to the generation of traffic and has no relation to this contrived impact of traffic. Ironically, the objector's own planner suggested that a much better location for this use would be on the larger farm lot directly across the street. While that might help eliminate some of the conditional use variances we are seeking here tonight, which are lot area and setbacks and coverage, it has absolutely no effect or impact on any of these alleged negative impacts that the objectors are complaining about. If we were on a 10-acre farm across the street, if our lot was 10 times the size it is today, would not have any impact whatsoever on the alleged impacts that the objectors are making, because they object to the use of a synagogue in their quiet neighborhood. Their argument is with the governing body who permits this use in the neighborhood. Mr. Gemma essentially made our case for us. The site can accommodate the use. The size of the site has nothing to do with the impacts that they are concerned about. The neighbors take issue with the use itself. And then there was a lot of testimony, or an attempted testimony, on the only other aspect that they object to that's not related to the use, and that's the architecture and the design of the building not being residential in character. The applicant concedes that back in 2013, when they were converting an existing house into a synagogue, they agreed as part of that approval to maintain the architecturally residential character of the structure. The existing house was literally being built into the overall design, and the size and scale of the building lent itself easily to comply with this requirement. While our experts testified that the materials and architectural forms are similar to the existing building and therefore similarly residential in nature, it just isn't relevant for your consideration tonight. There is no conditional use standard, there is no bulk standard, there is no regulation whatsoever in the Township of Ocean ordinances that requires a church or a synagogue or a mosque or any other house of worship in an R1 zone to be residential in nature and character. The use is permitted in the zone without regulation to architectural design or aesthetic compatibility. As was admitted to by the architect of the objectors, churches often have steeples, towers, bells, crosses, and stained glass windows, none of which are residential in character. Similarly, mosques have their own unique architectural features, including minarets, domes, arches, and bright colors. Again, definitively not residential in nature. Yet under the ordinance, they, like synagogues and any other house of worship, are permitted in this neighborhood without regulation on the architecture or subjective aesthetic design. What is important, and what this board does have jurisdiction over, is the height of the structure, and is that compatible with the surrounding neighborhood. And as was testified to by our architect and our planner and our engineer, the proposed building actually is less than the 35 feet, which is permitted for a single family home. You all live in town, you're all familiar with the area. There's a vast variety of house sizes and styles, and many homes even taller than what we're proposing. The conditional use variances we seek are for lot size, setbacks, buffering, and lot coverage. None of the property owners immediately adjacent and most affected by these requirements are objecting. None of the testimony, either from the objectors themselves or from any of their professionals, stated any concern or negative impact directly related to the variance relief we need. The only objection was the impact of the use itself, unrelated to the size of the property or the size of the proposed building. As you know, as I'm sure your attorney has advised you and you're aware, federal laws protect the practice of religion. While Mr. Gazarovski says you shouldn't consider this as a religious application, you should just consider it as any application. Well, you're not with authority to do that. The federal laws protect the practice of religion, and towns are prohibited from creating or implying any land use regulations that impose a substantial burden on religious exercise. And equally as importantly, a board is not allowed to consider alternative means of religious exercise, such as going to another nearby synagogue, even if it's close by. Our U.S. Supreme Court, not New Jersey, the U.S. Supreme Court has held, and I quote, "The availability of alternative means of practicing religion is not a relevant consideration in that analysis." So the number of synagogues in the area, how close they are, none of that is part of your deliberation or allowed to be considered. If a town is going to impose a burden on a religious use, for example, a zoning regulation or a condition to the approval, the restriction that's imposed by the town must be to protect a compelling government interest and be the least restrictive way to protect that interest. So a compelling government interest would need to be identified, and the least restrictive way to address that interest would need to be imposed. In the first instance, as you heard from all the testimony of your own experts through their reports, the experts of the objectors and the objectors of the experts of the applicant, there is no compelling government interest that would be frustrated by granting the approval as requested. Secondly, and most importantly, the applicant is open to and has conceded to any reasonable condition to mitigate the impact of the conditional use and bulk variances being sought. We have already agreed to widen the driveway to 20 feet to address the fire marshal. One thing I forgot to add at the beginning, there was a tree dying tree identified that we are agreeing to take down. So to the extent that it wasn't on our report, Ben, I just wanted to point out that we are going to, I believe it was shown as being taken down, but in any event. We've already agreed to enhance the landscaping, subject to the review and approval of the board's professionals. This will, in and of itself, ensure that any potential visual impact resulting from the setback variance relief will be fully mitigated. We've agreed to add bike racks. We've agreed to expand the access drive to the full 20 feet in width to address the fire officials' concerns. We've agreed to satisfactorily address the board engineer's comments with regard to stormwater management, which again addresses any compelling government interest that there may be with regard to stormwater and coverage. We have stipulated and agreed to a condition that any and all celebrations will be directly related to a religious ceremony, that there will be no social hall, that there will be no catering facilities, that there will be no commercial kitchen. The only condition that we're looking to lift is to allow us to use this on a daily basis and to allow us to have religious-based celebrations. We still concede that if the synagogue use ever ceases, we'll abide by the condition that the 2 lots would have to be developed as single-family homes. We also still concede that there'll never be a summer camp here. There'll never be recreation here. We're not asking for major changes to the application. We're asking for an expansion and for the daily use of the synagogue. Moreover, the proposal provides for many improvements over the existing conditions, all of which are great benefits to the neighborhood and, more importantly, in the context of the municipal land use law, the general welfare. These include improved on-site traffic circulation, an addition of defined on-site parking, the elimination of overcrowding during prayer services, and not only drainage improvements where none exist, but significant drainage improvements. The physical expansion of the building and daily use proposed is merely to accommodate the hundreds of Ocean Township residents who already live in that neighborhood and pray at the synagogue. Through the testimony presented and concessions made throughout this process, the applicant has proven that the site can continue to accommodate the use despite the conditional use variance relief. And moreover, we have demonstrated that the benefits of granting the variances sought far outweigh any detriments. In light of all of that and the federal regulations governing decisions based on religious uses, I would respectfully request that the board vote in favor of this application, subject to the conditions that the applicant has stipulated to.
And the basement for storage only.
Oh, I'm sorry, and I missed that. And the basement would be for storage only. I think I hit every other condition.
Yeah.
Mr. Higgins, I do have your June 14th report and Mr. Matlock, your June 7th report. Are there highlights? I believe there is a change
There's,
to the fence.
the one change from my report is that the applicant has offered to remove most of the fencing that's on the proposed plan, and that the only wall or fencing would be the 10-foot high wall on the northern property line adjacent to the residential property that fronts on Larchwood.
And
just to the
that
north.
requested it.
And that's requested by the owner of that property. And so that's the only real property that would be impacted by that 10-foot high wall. Otherwise, my report's unchanged.
Okay, Mr. Matlock?
Yeah, I don't have any changes to my report either. I think all my questions have been answered.
Okay, so if someone will offer,
Well, you're gonna do it just 2 steps. You're gonna do
Okay.
site plan on what's separate. Just
Okay.
makes it easier. If you would vote on the conditional use and all of the incorporated variances that are set forth on our agenda as one, and then the site plan itself, which we can throw the conditions into that one, so it makes it a little easier. So the first vote would be to grant the conditional use and all of the named variances with the exception of the 18-foot wide aisle and drive-through.
Correct.
That would now be.
Well, actually, that's not a condition, though.
No, we're gonna
Okay,
do
yeah,
the conditions
and the
are the lot
variances.
with the front setback and the side yard
Okay.
setbacks. The
And-
rest are
Right.
bulk variances.
Correct.
Nope.
Nope. Go
The
ahead.
conditions are, well, first of all, you've got the lot area, lot width, and the side yard setback of the building from Larchwood on the principal building. They're existing and previously approved conditions. Then you have 5 other conditional use deviations. One is the front yard setback of the mikveh, 65 feet is required. It's 47.2 feet from Old Farm Road. So that's one. Then you have the side yard setback of the mikveh. 50 feet is required and 13 feet is proposed on one of the sides. The other side conforms. Then you have the rear yard setback of the principal building, the expansion. There's one small corner because the lot jogs that there's a distance of 15.8 feet from the principal building to a very small portion of the side of the rear what was really a rear property line functions as a rear property line. And then maximum lot coverage, 30% is required, 34% is being requested. And then you have the buffer, 25-foot wide buffer from the parking area. There are 3 areas there. You have 8 parking spaces on the south side. They're 11.3 feet from the southern property line. 14 spaces on. What?
This is all part
What?
of it.
Yeah, it's all written out there, and it's in
all
my
written out there.
notice.
It's all written out there
Yeah.
in the resolution.
Okay,
Yeah,
so-
Yeah,
so
so we
it's the buffering is the last one.
Okay.
So we would
Okay.
vote on the conditional use where it doesn't meet the conditions of the requirements for a house of worship and the bulk variances as set forth.
Yeah.
That would be the first vote. Somebody needs to move that one way or the other.
I'll move subject to Mr. Higgins' conditions.
Is there a second?
I'll second.
Amy, please call the roll.
Yes. Yes.
Yes.
Yes.
Yes.
And now the site plan as submitted with all of the additions that Ms. Krimko set forth on the record.
Site plan with conditions, okay? Is there a motion? Is there a second?
Second.
Amy, please call the roll.
Yes. Yes.
Yes. Yes.
Yes. Okay.
Thank you very much.
Okay, hold it, everyone.
You want me to have everyone step out, or you want to?
Yeah, step out. We have 2 more cases.
Everybody, the large group, go in the lobby. They have 2 more cases. Be quiet till you get in the lobby.
Take them outside.
Sorry.
Thank you.
I would just start.
Ron, I'm gonna start. Were you? Oh, okay.
Thank you.
Our second case, Thomas and Susan Krautler,
Okay.
Block 22, Lot 23, 229 Larchwood Avenue, Ocean, Zone R4. This is a request for certification of use for a multi-family home in a single-family zone.
Thank you, Madam Chair. My name is Gordon Gemma. I'm the attorney for the applicant. I'm wearing 2 hats tonight. As indicated, this is an application for certification of a pre-existing use. I'd ask Mr. Steinberg to accept jurisdiction. Notice has been provided and is acceptable.
Accepted jurisdiction is in order.
Thank you very much. Tonight I have only one witness, and we shall be quick. Before I begin, I'd just like to indicate Mr. Higgins put together a report. We agree with the report that Mr. Krautler and the applicant has put together a preponderance of evidence indicating how long this place has been used as a 2-family structure. It in fact has been used as shown by an ad in the Asbury Park Press since at least 1941 as a 2-family structure, and that we've provided, Mr. Krautler's provided affidavits, notices, agreements of sale, all which indicate the prior use. I'd ask the board just to take notice of 2 things real quick. One, this ordinance that would prohibit single-family, 2-family uses was adopted in 1992 by the board. Prior to that, your 1990 master plan indicated that as far back as 1978, Ocean Township was in fact an area of both single and two-family homes, and it changed in 1978 because, quote, the law changed in 1978 to ignore or to prohibit in some places two-family homes. That's actually page 10 of your 1990 master plan. So in terms of proofs that's needed, when did the law change? It seems that the law changed around 1978 when you adopted your ordinances, which makes sense because, in fact, the land use law that most ordinances today are based on was actually adopted in 1976. So 2 years later, you actually changed that and now prohibited two-family uses. So what I'd like to do is very quickly qualify Mr. Kreitler. I ask him to be sworn in.
Okay, can you state your first and last name?
Thomas Kreitler.
And do you affirm to tell the truth, the whole truth?
I do.
Mr. Kreitler, could you give me just your address, please?
Yes, 304 Roosevelt Avenue.
And how long have you lived there, Mr. Kreitler?
So I moved there when I was 12 years old. I've been in that house for 51 years.
And regarding the location of the residence at the subject property, where is that compared to your house?
So my home is on the corner of Roosevelt and Larchwood, which is also known as Pine Street. It's the dead end that faces south. And the subject property is the only other house across that dead end, which is known as 229.
And since for the last 51 years, have you known how that house has been used?
I have.
And how did you know that?
Well, because I lived there, because I was friends with the neighbors, the Jeffers, those are the folks that sold it to us, for that entire period of time from my childhood until and continued.
But you acquired this house, is that correct?
I did. I purchased this house in April of this year.
And is Miss Jeffers, who the original owner that you bought it from, does she still live in one of the units?
She does. She lives on the first floor.
Okay, and the other floor is vacant, is that correct?
It is vacant. Yes, that's right. It has a separate entrance and a
Right.
separate meter.
So just to be real quick, you intend to continue to use it as two-family house, is that
I
correct?
do.
And did your lawyer say, don't do that until you come in front of this board?
Of course. Yeah.
Okay, wise choice. And so, real quickly, what steps did you undertake in terms of prior research and occupancy, in terms of getting certifications that were looking at all public records that you all submitted in front of this board, who has these copious records?
Yeah, so I had been interviewing Mrs. Jeffers with respect to her knowledge. She, God bless her, is 102 years old now, her whole half her life. So she had a lot of knowledge. I also interviewed and saw a certification from George Siri, who is an attorney, or recently retired attorney, served as an attorney in Long Branch for 50 years and was a Superior Court judge there for 30 years. He's Mrs. Jeffers' nephew, and he's represented her for his entire legal career, has limited knowledge of that. Also, Robin Kucharczyk, who was a tenant recently for 15 years in that property. I also had the opportunity to review Mr. and Mrs. Jeffers' tax returns from 1958 through 2015, each of which indicated a reporting of rental income from that property. We also were able to access the 1958 purchase agreement and also the affidavit of title, documenting a purchase from the prior owners, both of which indicated that it was a two-family house. We reviewed background reports on some of the past tenants as they were publicly available. Also researched telephone directory listings, found a number of those associated with past tenants, and then found an extensive number of newspaper clippings that essentially showed the life activities of those that lived in that home for all of those years, back to, as Mr. Gemma pointed out, 1941. I remember specifically one from November 25th or 26th, 1941, which was 11 days before Pearl Harbor. So that's how long this property at least has been used as a two-family.
Other than guys over this board, professionals, crazy looking up stuff, during your day job, what do you do for a living?
So I'm a broadcast journalist, and I specialize in home improvement. I spent 20 years as a professional home inspector and then entered the media business. I host a nationally syndicated home improvement radio show called The Money Pit that airs every weekend across 400 radio stations in the United States and Canada. And I also have a pretty successful podcast about home improvement, so I'm a construction expert.
Right. Even though you're not being offered as an expert, in your observations, has this house ever been a single family and been converted, was it built, in your opinion, as a two-family?
Yeah, not to my knowledge. It clearly is built as a two-family in the structure of it. There's no indication that the first and second floor were ever connected internally, except for the access to the second floor apartment is through a deck on the back of the property, and the access to the first floor is on the front.
Right. The applicant has submitted photos, the applicant has submitted affidavits, they've submitted a summary of all the evidence. My client can go through that painstakingly, or if the board has decided they've had enough, we can stop right now.
We have the report. We're good.
Thank you. That's it.
But it's in again.
No synagogues on the second floor. Yeah.
Okay, questions?
I couldn't help myself. That was Ms. Crimcorn.
Any questions or comments from the board? Okay. Any questions or comments from the public? Okay, motion to close the public hearing.
I'll move.
Amy?
Yes.
Yes.
Yes. Yes.
Yes.
As the board has had experience with a couple of these in the last couple of months,
Yeah.
you know, once the ordinance changes, you have 1 year to get a zoning determination of a pre-existing non-conforming use, which is the two-family. Beyond the 1 year, which changed in 1978,
Yeah.
they need to come to this board for this type of approval. We presented the testimony. He's asked you now to vote upon that approval for a conditional, for a, strike that, for a
Certificate of
non-conforming
Yeah.
Yeah.
and restriction.
I'm sorry, our attorney is tired like the rest
Yeah.
of us. We're going to move forward.
Okay.
Yeah. Yeah.
Is there a motion? That was to close public. I'll second. Amy, please call the roll.
Yes.
What?
This last month, right?
Yes.
Yeah. Yeah.
They had the late, no, the
Yeah.
third story.
Third story. Yeah.
Yes.
The third
Late
story. Yeah.
last
Yeah.
Thursday.
Yes.
Yeah.
Thank you very much. We appreciate it.
Thank you very much.
Thank you. Okay, the last case is Adrian Shalom, block 25.12, lot 9, 228 Belmar Avenue, Ocean, Zone R4. This is an application for bulk variance approval for an existing patio installed without permits within the setbacks, as well as a pool fence installed within the required setbacks. And okay, and Adrian Shalom. Okay, you can raise your right hand, and you affirm to tell the truth, the whole truth.
Yes.
Okay. Will you please tell us about the request?
Unfortunately, I don't know enough about it to say. My son had a stroke last summer, July 13th until October 28th. He was in the hospital. I didn't take care of this. I had my accountant and my partner take care of it because I was taking care of medical stuff. So he helped me take care of everything.
Yeah, I can explain it to the board if the board would like.
Yes.
I don't know.
Basically, they have an undersized lot. They have a pool with a patio surrounding it and the pool surround. And a small portion of the pool surround requires a setback variance from the side yard. It's required to be 10 feet. This is like a little piece that juts out, and it's 5 feet at its closest point. I think it is. Let me see. No, I'm sorry. It's 3.1 feet to the side. Okay, at the closest point, but that's just a small portion of it. And there is a slide located about 5 feet from the side property line on that little bump out. But there's a 6 foot, yeah, okay,
That was in the original plan, and we got approved.
okay, good.
When the original plan went out, if I can speak, I don't mean to
Okay,
be
yeah,
rude.
yeah,
The original plan went out, I knew everything that was going on.
yeah, okay,
Then after this happened, it just so happened that my son is handicapped.
Yeah, okay.
And he needs the pavers, and
Yeah,
I'm trying
yeah,
to get
yeah.
railings to be put in,
Yeah,
so you could
okay, yeah, that's,
close it.
but basically, it's really not
Engineer did
something that's very, it's not really intrusive. It's something it's a minor change there. And then the house is only set back 17 feet from the street, and the ordinance requires a 30-foot front yard setback. So the pool surround is set back just beyond the house. So you need a front yard setback for the pool surround and the fence, but they're actually behind the front of the house, so they really meet the intent of the ordinance. The intent of the ordinance is that the surround, the patio and the fence not be in front of the house and be that high. So those are the variances that are necessary. I think they're really inconsequential given the nature of the neighborhood, and most of the houses in that neighborhood are set back about the same as what this house is set back.
Okay, Mr. Matlack?
Thank you, Madam Chair. The only minor comments I had were regards to stormwater management or drainage. Can I ask, when was the pool and the patio installed?
I'm sorry. If you can
Testify,
No,
but
no,
she's going to swear you in.
You're fine. If you can state your first and last name,
Stephen Rubinoff?
and do you affirm to tell the truth, the whole truth?
Yes, I do.
Okay.
Apologize.
How are you connected with the application so that it's on the
My
record?
accountant and my partner.
The pool was completed in August of last year, and the pave was around the same time.
Okay. And since August,
For that drench thing that they did,
You-
they
you-
made us do that, and they came and they approved that, I was aware of.
right,
as
that
well.
you're referring to the recharge area
Yes.
that's shown on the plan?
Yes.
Okay, and in that time, since it was installed, have there been any drainage issues or complaints from your neighbors or anything like that?
None whatsoever.
Okay.
Zero.
Yeah, Madam Chair, they do show grades on the plan, which I do appreciate, and I've looked at it, and it doesn't appear that there are any issues. It looks like everything's draining towards the street, so I don't have any concerns.
Okay. Do you have any other testimony?
Only thing is that I tried to do everything legal with everything, and when the engineer came and the landscaping was there, that I made sure to be home and be in charge of everything. So I think only when we sent in for the certificate of occupancy, this came to be an issue, and I was pretty flabbergasted, but in any event, we're here, and I hope it just gets approved, that's all.
Okay. Questions from the board? Presuming no invisible people are here, no questions from the public, and we'll have a motion to close the public hearing.
Motion to close.
Second. Amy?
Yes.
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 Yes. And will someone offer for the bulk variance approval?
I'll move for a positive resolution.
A second.
Okay, Amy?
I'll send you that too.
Yes.
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 Probably do that over the weekend.
Yes.
or Monday.
Yes.
Yeah, I'm on the
Okay,
road
you're set.
tomorrow.
Thank you. Have a good evening.
Thank you very much. We appreciate all your assistance, everything. Thank you. Have a great night, everyone.
We need a motion to close?
Oh, sorry.
We're almost there.
You guys, you can go.
You're done.
You're done.
You guys are
Yeah.
You're all
I
done.
have permission
We're not.
to leave?
Yeah, you have permission.
Not in
Thank you.
trouble?
So we have a motion to close, a second.
Thank you, everyone.
In favor?
All in favor? Aye.
Opposed?
Now we can leave.
Oh.
Awesome job.
Thank you, everyone, for tonight.
For everything.